Please go ahead, sir. Yeah. Now, I want to welcome everybody, and I hope audible. This is National E-Summit on Insolvency and Bankruptcy Code, post-pandemic and 1-year suspension. We are very fortunate to have the very best panel that one can imagine on this topic, and we have the whole session divided into two parts. This is the first part of the morning session, where we have with us as chief guest Shri Bhupendra Yadav. He is the National General Secretary BJP and also the Member of Parliament, and he has been associated with IBC in the various committees. After that, we have Dr. Sahu, who is the chairperson of IBC and who will be speaking to us today. We have the former Finance Secretary, Shri Subhash Chandra Garg, from the Ministry of Finance, and he'll be delivering a special address today. I have the honor to host a panel which is very rich, and because we are running out of time and it's 12:15 is the dead end when we need to close, I'm going to request one of the panelists who has a meeting and just joined us because of our because the conference and this seminar is on such an important topic, Mr. Balwinder Singh, CMA. He is the president of the Institute of Cost Accounting of India. Before I go further, I'm just going to request him to share his thoughts with us, and then we will go over to Dr. Niranjan Hiranandani ji, who's our president, and he's also the co-founder and MD of Hiranandani Group of Companies. We all know about it. Then we will go to Mr. Raman, and then we will go to Mr. Manmeet Singh. So with this brief introduction to the important topic of Insolvency and Bankruptcy Code, post-pandemic, which we are all worried, let's get started with the initial remarks of our panelist, Mr. Balwinder Singh. Balwinder Singh.
A very good morning to all. Shri Bhupendra Yadav ji, National General Secretary BJP, MP Rajya Sabha. As chief guest and guest of honors, Dr. M.S. Sahu, chairperson of IBPI, Shri S.C. Garg ji, former Finance Secretary, Ministry of Finance, Dr. Hiranandani ji, President ASSOCHAM, and my co-panelists. It's a pleasure to be here at this National E-Summit on Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code Amendment Ordinance 2020 suspended the applicability of Section 7, 9, and 10 of the IBC Code for 6 months to protect the corporate entities defaulting on payment obligations during this COVID pandemic. The global spread of COVID-19 pandemic and consequent lockdowns have adversely impacted businesses in different sectors across the economy. To overcome a highly distressed market scenario and address the credit exposures of various businesses, the Government of India has introduced various economic relief packages, legal and regulatory measures, the latest being the amendment to Insolvency and Bankruptcy Code 2016. In what may bring about major reform and efficiency in the insolvency regime in India, the IBBI has proposed to limit the number of cases and insolvency can handle, as it is noted that few IPs are handling too much cases. In this recent discussion paper, the board noted the skewed work allocation and has come up with a matrix for allocation of cases. Keeping in mind the provisions of Companies Act 13, the skewed work allocation amongst the IPs, and the observation of Supreme Court or the auditing authorities, and given the expansive and intense responsibilities of IP in the corporate processes, it is proposed to issue necessary guidelines to IPs advising them to limit the maximum number of assignments handled by them at a particular point of time. The IBC Ordinance 18 has brought relief to the MSME enterprises by relaxing the applicability of provisions of Section 29A. As regards submission of resolution plan in case of such entities, they favor. It is one of the most significant amendments under IBC and has a wide impact on whole insolvency resolution regime. The draft Special Insolvency Resolution Framework Bill for MSME recommends 90 days timeline instead of the existing 330 days for completion of the process It permits promoters of a defaulting MSME to submit resolution plans. It's imperative that regulatory measures are supported by necessary infrastructure and effective system. In view of the recent COVID situation, the corporate insolvency resolution filing under IBC has been suspended for 6 months for any debt default post 25th of March 2020. Therefore, many companies and lenders will not be able to utilize the restructuring framework under the IBC during these 6 months, even if they wish to do so. The Delhi High Court has sought the center's reply on the plea, challenging the IBC ordinance, which suspended proceedings against defaults arising post 25th March. Even the recent order of NCLT has rekindled the debate over what is the best option for banks and other creditors to recover their dues. The resolution of the case monitored by the court or out of the court or settlement with the lenders. NCLT, which earlier this week allowed the withdrawal of a case and allowed Burda Drug India Private Limited, a corporate debtor, to run independently on settlement of dues with operational creditor, highlights the way a large number of India's bankruptcy cases are handled. Official data showed that since the Insolvency and Bankruptcy Code and judicial ecosystem came into force in December 16, the number of cases withdrawn on settlement is as high as 157 by 221, and cases have been resolved under the tribunal. The fear of bankruptcy action has helped settle over 9650 cases involving claims of around 3.7 lakh crores, with the companies and their promoters settling the dues before the case was admitted in NCLT. The other advantage of credit is the quicker disposal of cases. The average time taken, which was 415 days, including the excluded time, and excluding the excluded time, it comes to the 375 days, as against the 4 years which used to take in the pre-IBC era. While restructuring outside the code is a possible option, it would not offer certain benefits available under the code, such as moratorium on legal proceedings or relaxation, exemptions from statutory provisions or approvals. Further, the outcome of such restriction does not have the same binding effect as the resolution plan under the code. It is therefore become imperative to consider and adopt novel resolution mechanisms under the code, which can ease the pressure on the tribunal. A pre-packaged insolvency is one of such novel resolution mechanisms, which has been extensively used in the United States and United Kingdom since the 1980s. A pre-pack is a pre-planned process in which a financially distressed company and its creditors reach an agreement with a buyer for its sale prior to initiating insolvency proceedings. With this initial setting the tone, I'm thankful to the ASSOCHAM for inviting me here, and thank you so much.
Thank you very much, Mr. Balwinder Singh ji. This was very good introduction. I would now find, just checking with Mr. Rajesh, should we go on, or has Mr. Bhupinder Yadav joined? I understand.
Hello.
Yeah,
sir,
Rajesh.
He will not join.
Yeah. He'll not be able to.
He will not join, sir. Yes.
Okay. So I'm sorry to mention that. I knew he had another engagement, but then probably the time has gone and he has to rush for that. Then let me invite our president, co-founder and MD of Hirandandani Group of Companies, Dr. Niranjan Hirandandani, to share his thoughts. Of course, he's our president, so he most probably like to welcome all of us too. And we are all doing this as guidance. So on the mic is yours, Dr. Hirandandani ji.
A very, very good morning to each and every one of you. I hope you are all keeping safe, keeping well, and taking care of each and every one, because that's the most important thing of all. All the codes will come number 2. So I wish you all to keep good health and happiness of all the things that are happening. My special thanks to Dr. Charan Singh, who has been so efficiently chairing the Association for Banking. But more than all that, he has taken leadership in ASSOCHAM in such a tremendous way that I cannot but thank him tremendously for all the action that he has been taking, all the things that he has led. And I'm really thankful to him because he's taken a lot of work off my shoulder. So thank you very much, Dr. Charan Singh. So it's very happy. Dr. Sabut, Chairperson of the Insolvency and Bankruptcy Board of India. Sir, we are extremely honored to have you here today to give us an insight and a perspective as to how you see the entire activity in terms of the Insolvency and Bankruptcy Code. The business community, sir, is in a dire state. We were just talking about a little while ago is the negative growth of interest which is taking place maybe to the extent of 20%. But let me point out to each and every one of you here today that there are fields of activity which have not taken off. So whether you look at the hospitality, you look at the restaurants, you look at many sectors like aviation and other sectors, they are in dire states when they are 90% down or 95% down. And obviously, the challenges of the entire economy are still really being faced by this sector. Hence, this was the reason why the deferment did take place for a period of 1 year in order to see that excessive insolvency and bankruptcy was not done because of the pandemic situation that we faced as a very special case. And hence, I'm especially thankful to the entire panel to really work out and say, what are these special situations merit? Is there something else that we also need to do in order to save the situation? One of the big problems that I got from the banking sector and the NBFC sector was as follows. Till this entire resolution package of a one-time rollover, which has now been approved by the Reserve Bank of India and put up before the KV Kamath committee in order to formulate the regulations to this, was the fact that even when the defaults did take place, and there were many, there were some which really should have gone under the insolvency package if the banks are not really permitted to do a one-time rollover or a solution. So we are really grateful that the delay in terms of being able to access the insolvency court and the benches is really going to be deferred, but is joined with the fact that such a one-time rollover is happening. So I think this is a dual benefit to the banking and financial sector, which has become very important with the IBC ordinance as well as what the RBI governor has presently done. So we are looking forward to the direction, sirs, from all of you to give us an idea as to what more that we need to represent to the government of India in terms of changes that we need to do to see the pandemic situation and also the post-pandemic situation. Is it going to be that all the people will then rush to the situation in terms of the period when it gets over? Will that resolution get completed by the banks and financial institutions? What are the sectors which will still be undergoing a lot of pain? These are the kind of overall umbrella issues which industry would like to pose to you. I'm not getting into the sections of IBC and the changes that have been done. You are better at guiding us and giving us guidance to ASSOCHAM as to how we must proceed with the matter and take representations to the powers that be and the government that be in order to make whatever changes and modifications are required in order to bring the economy back. My view personally is that I think that the negative 20% is an excessive statement which has been made in the press. I do believe that the negative growth at the end of the financial year would be to the extent of about 5%, provided the agriculture segments are done and the little more opening out committed by the government does take place in the cities and important metropolitan areas. We are pushing in order to see this happen, but as the Prime Minister has correctly said, हमको जान और जहान को दोनों बैलेंस करने की आवश्यकता है. And if we can get this correctly, and we get your guidance today on the Insolvency and Bankruptcy Code, we will be extremely happy because we do believe that these coming and emanating from people like you will make a world of a difference for our representations to the government and also to the community of businessmen and people, especially the SME sectors. Thank you very much for coming. I'm really happy to have all of you. We are delighted, happy, and I hope to God that the next time we will not meet virtually, but we will meet one-to-one where we can actually hold hands and give each other a good embrace. Thank you very much. Have a wonderful day and keep safe.
Thank you so much, Dr. Hiranandani ji. This was very encouraging, and you've put the questions before the panel, which we as a trade association need to go and represent to the government. I think that's a very practical issue, and I totally agree with Dr. Hiranandani. My own feeling is that some of these think tanks are projecting India's growth too much skewed in towards south. I don't think that is where we are heading for. I still have a feeling that the busy season has started. The first thing in the morning today, I got it on the Ganesh Chaturthi, the greetings, and I said, look, this is it. We are now entering a positive phase. Too much of negativity in the last 6 months, and I think we need to get out of it. In any case, the IBC is looking for light at the end of the tunnel, and that is also one thing which I look at as a sign of positivity. Let me go to the next panelist, because each of the panelists are so good that I should not be taking their time. I'm moving on to Mr. Raman, who's our National Council Head of IBC. Mr. Raman, please.
Thank you so much. A very good morning to all of you. A special welcome to our guests of honor, Dr. M.S. Sahu and Mr. Subhash Garg. My personal thanks to the President, Dr. Hiranandani, for giving me the opportunity to hold this position as the chairman of the insolvency panel of ASSOCHAM. It is certainly a new experience for me. What we are doing as National E-Governance Services is to host and operate and run the information utility of the country under the IBC and under the guidance of Dr. Sahu. And that is really where we come in and bring in our efforts to galvanize the space of insolvency. What the information utility is bringing forward is an evidence of electronic evidence, let me say, of contracts between any two parties. Of course, the focus is on financial contracts, and therefore what the information utility brings in is a ready evidence for any party to a debt, be it financial debt or operational debt, to carry that forward to not only the legal fora available under IBC, but this could be to any legal forum, considering that this is electronic evidence. And that is really what I will now bring into the pandemic context, where I only see the silver lining. And the way we look at it is that every new institution that comes in has to innovate, has to look at how it can deliver its promise. And I will once again go back to what Dr. Sahu had said probably 3 years ago, that there should be several avenues for citizens of the country, for business of the country to use to carry forward their business, whether it is the securities market for raising money or whether it is the legal fora for resolution of disputes. But at the end of the day, dispute resolution is something which is part and parcel of any contract. And therefore, the IBC is one more mode of dispute resolution. I think those words ring even more true today when we're looking at the ability of the IBBI and its supporting organizations, including the information utility, to provide additional services to the country and to innovate and keep in touch with the ground realities. And that is really where I must highlight one excellent move which came about after a lot of efforts. The effort was started by Dr. Sahu and has now finally been endorsed and blessed by the Department of Financial Services. And this is what is known as a digital document execution platform on the information utility of NESL. What this basically does, as the words will suggest, is provide an end-to-end digital experience for documentation of any contract. So of course, the easiest thing to visualize is contracts between banks and their customers, where sitting as we are in our respective offices or homes, we can conclude a contract within a period of 3 to 4 minutes, where there is absolutely no face-to-face contact and everything is completely digitized. Of course, the banking system and all the businesses in the country know that documentation is a tedious process, and therefore what the DFS has done is asked all the state governments to amend the stamp duty rules, which is under the jurisdiction of respective state governments, to allow for digital e-stamping. So digital e-stamping plus digital signature on the IU platform causes the contract to be complete within a few minutes. And I honestly believe that as a group, as ASSOCHAM, we should put our hands together for this initiative, which came from Dr. Sahu. And he is a person, if some of you do not know, was one of the authors of the DMAT success story of India in the capital markets. And I think what we are really going to see in the next few months, which will accelerate because of the COVID situations, this is something which the banking system and the NBFCs are really looking forward to. So already 6 states have given permission for digital e-stamping. We expect the other states also to follow. And therefore, we're creating an ecosystem of a digital execution, which will cut costs for people tremendously across the board. Now, I can only say that this particular innovation is something which has come about with government being so proactive, because of the COVID situation which we have faced. And therefore, it is another example of, I think, some excellent administrative leadership shown across the board. So I would really say that, yes, this is something which is a complete black swan event. I think it is, will be chronicled in the commercial history as that. And how we get over it is really left to, the leaders of commerce and administration and government to look at different ways of, moving forward. So I really look at, the future as all of us putting our heads together and coming up with probably multiple solutions to try and solve the problems that we face. So thank you very much, and I look forward to the panel later.
Thank you, Ramanji. That's very good. And we are now moving forward to Mr. Manmeet Singh. Looking forward to your views, please.
Thank you, sir. Good morning to all of you. What I will try and do is cover 5 or 6 issues which I feel arise in the context of the ordinance, and what can be done now that we've seen a few months of the ordinance and a few months of the pandemic, and we have a better sense of how the situation may evolve. I think the first important thing is that the ordinance recognizes that today defaults may happen for reasons which are outside the control of corporate debtors, and also importantly, that these are markets in which it may be difficult to find adequate number of resolution applicants. I think the second thing is also equally important. The code was written for efficient markets, and today we're in the midst of broken markets, and therefore the code where the threshold is a simpliciter default may not be appropriate. And I think that's what's been recognized by the government and IBBI, and therefore we have this ordinance. Now, this ordinance extends for a period of 6 months. I think one will need to examine whether there is a case, sector-specific case, where the effects of the pandemic may last beyond 6 months. All sectors of the economy may not recover together at the same pace. So, for instance, as it was mentioned earlier, that hospitality, travel, these may be sectors where the impact of the pandemic may last longer. So, I think this is something that will need to be considered. Another important issue which rises, in my view, is that to begin with, Section 10, which is voluntary filing, has also been suspended. Now, this is a filing which happens with the consent of shareholders. A special resolution is required. So, therefore, this is a route which may be considered for being opened up, because this would allow corporate debtor-driven restructurings to start, which may be required given the impact of the pandemic. So a Section 7 by the financial creditor and Section 9 by the operational creditor is understandable given the objects of the ordinance. But a Section 10 may be considered for relaxation at some point of time. and also maybe carving it out of the first proviso of the section. The first proviso of the section provides that no filing ever may be made in respect of a default which occurs during this period. Now, a section 10 filing may be considered for being carved out, although as RBI has now recently allowed one-time restructuring, so that is also another alternative window which has become available to restructure the debts of corporates which may suffer stress during this period. However, I think IBC is an important piece of legislation which balances this interests of all stakeholders. In an RBI, in a bank-driven restructuring, the cost of restructuring, so to say, or the burden of restructuring, so to say, is picked up by one set of creditors only: the banks and financial institutions like NBFCs, even bond holders, NCD holders. And there's been a lot of borrowing from the bond market in the last few years. They also perhaps would be outside the restructuring framework of the RBI. And given that, it may be considered, and Dr. Sahu is here, so my recommendation, sir, would be to consider some relaxation to a Section 10 filing. It would also enable promoter-driven prepacks where the promoter is not barred under Section 29A. It may be an appropriate route for considering promoter-driven prepacks, especially where the promoter is somebody who is otherwise eligible under the IBC Section 29A to bring forward a resolution plan. Section 10 may provide a route for the same. I think it is also important that when we are looking at this, to look at, as I said, certain sectors which have suffered significantly during the pandemic, and certain sectors also which even prior to the pandemic, such as pockets of the real estate sector, which even prior to the pandemic were going through peculiar circumstances of their own, and those circumstances have just got magnified. There is a demand issue in that sector, at least in certain parts of the country. So it may be considered whether a special regime under the framework of IBC is required for that sector. For instance, there has now been a lot of learning from the JP insolvency experience and a couple of other insolvency experiences. And so there are a couple of important companies which are today being restructured, or alternative solutions are being looked at by the Supreme Court, say, for instance, in the case of Amrapali or Unitech, whether a special regime is required for this sector, considering its own specific issues, which is really that at this point of time, people don't have the confidence to invest in under construction projects. So therefore, is a bespoke sort of a solution required for this sector? That may also be considered. And finally, I think the impact of the pandemic on the existing processes. Now, given that the ordinance recognizes that this is a market where too many resolution applicants may not come forward, so that may be equally true for processes which are underway. So therefore, is there a case for an extension of 180-day period or a 180 to 70-day period under the statute itself, while the IBBI has brought in regulations to change the inter se timelines of various activities which are required to be undertaken within the court? But given that most resolution applicants also are likely to be extremely conservative at this point, therefore, there may be a case for extending the 180 to 70-day period timeline, taking the same into account to facilitate value maximization. I think that's an important aspect which needs to be considered, that at this point of time, the resolution plans which are likely to come forward may actually be at distressed values. Another interesting point which arises in my view is what happens to the determination of liquidation values and fair values which were undertaken prior to the pandemic and are now if affected on account of the pandemic. So is the RP enabled to seek a revised liquidation value and fair value from the registered valuer and present it to the COC? Because the basis of valuation which would have been undertaken at this point earlier and at this point of time would be entirely different. So that may also impact the entitlements of various classes of creditors. For instance, operational creditors under the resolution plan need to be paid at least the liquidation value. Now, the liquidation value which was true 6 months back is certainly not true today, and the resolution plans which come today would reflect today's value. So it may result in challenges where a resolution plan which is appropriate for today's circumstances and otherwise viable in today's circumstances may not be able to go through because the resolution plan does not propose to pay the liquidation value which was determined prior to the pandemic. So these are some of the issues which arise in my view, and therefore can be considered by the panelists, ASSOCHAM and IBBI for appropriate suggestions to the government. Thank you so much. Thank you, everyone. Thank you for the opportunity.
Mr. Manmeet, this was really very good. I'm going to request you if you can send us all those in writing, and we'll keep you informed. We would like to take up some of these issues with the government. It's just fortunate that we have Mr. Sahu here with us, and Mr. Garg is speaking now after you. So he's going to share some of his thoughts. They are the people who are at the helm of affairs and who have been designing these policies. So thanks very much for bringing these issues up. Now it's time to go to our special address, and I'm going to request Mr. Subhash Chandra Garg, the former Finance Secretary, to please deliver his special address. And if he wants to also cover some of the issues which have been raised by the panelists, and some of them are very important, knowing him and his knowledge base, I'm sure he has views on it. So, Shri Garg, the mic is yours. Please share your thoughts. We'll welcome you to deliver your special address.
Thank you, Dr. Charan Singh, and thank you to all the fellow panelists today. I would speak today from the broader policy perspective, what the IBC was intended to achieve, what it was doing, and how the moratorium and suspension and other things are affecting the IBC as a instrument of resolution of the insolvency. That would be the perspective I would be speaking, but we can always discuss many other issues which have been raised. See, in India or anywhere else, basically there are two entrepreneurs who actually make business happen. One is the entrepreneur himself, and the other one is the financer. No entrepreneur worth the name with the kind of capital and the financing required can sort of put together a business, especially a large business, without getting the finance from the financial system. The financial system provides the bulk of the finance, and in that the banks provide the principal finance to the entrepreneurs and the businesses. The other, in a way, the providers of finance like operational creditors or even bond holders are in a different sort of league or capacity than banks. Operational creditors typically lend or provide credit in the form of working capital, raw material, or some services payments and things like that. And therefore, they are in control of stopping the further supplies if needed and if they are not paid for. And therefore, in aggregate, the dues towards operational creditors would tend to be much lower than the dues to the banks, which fund the entire capital, fixed capital, as well as the bulk of the working capital. The bondholders do provide, but bond is a market instrument. So whether you allow the IBC to go or some company to be taken to the IBC route, the bonds are typically valued in the market, and therefore their values keep on going up and down depending upon what the true state of health of the business is. And therefore, even if you take it to the IBC or you don't resolve them under the IBC, it does not really matter. Today, there are lots of bonds which are selling at 20%, 30%, 40%, or 60% of their face value, which by the market and the bondholders. and bondholders are forced to take that haircut in a leaves essentially the banks as the principal stakeholder in the resolution process whenever any business goes bust. And to my mind, and that is the principal architectural reason the way the IBC in India has been structured, that finally there are two sides. Either the business believes that it has become bankrupt, it's no longer a going concern, or it is a going concern, it's a constantly bleeding and loss-making kind of concern. And therefore, it needs to resolve and declared insolvent or liquidated. And the second is the bank which has lent a lot of money. You just look at from the banks and the non-banks, that is the whole lot of money. We had experimented in India a lot of other instruments for enabling the bankers to recover the authority to the courts in the security and the asset and enforce it, and a lot of other these, or you can say the bank could have sold not really help the banks in much the way it was expected. And the conclusion was that this is because that all of these leave the failed businessman, the failed entrepreneur, to remain in charge of the business or the enterprise or the company, so to say. And therefore, if we do two things, and that is trying to get at, that you give the principal authority to the bankers to decide how much to recover and how much to give as haircut and things like that. And secondly, enable that or that failed businessman to be forced out of that business. These were the two basic instruments which have been built. And when the IBC came into being in the country in 2007, one can for given the our previous experience, the time taken to resolve a business in case you don't pay by the bank going to the IBC, many of them started behaving, and also out of the court kind of resolution, many of them paid back to their banks and all. And we have data about 4 lakh crores, etc. And that's a very large amount in the Indian context, was recovered for the banks. Banks had also developed a kind of business sense because they were protected by the process that yes, given the state of affairs of the business and all, this is what you can recover, and therefore the kind of haircut which the banks would accept under the IBC process was simply phenomenal. And this kind of big decisions could not have been taken if the IBC was not there. Now that is where we were. Now this COVID situation hits us. COVID has transformed what Mr. Hiranandani was also mentioning, and other panelists also talking. There are some businesses which are gone or so much dented forever that they would perhaps not be able to be recovered or nursed back to the to health any time, 6 months or 1 year or 2 years. They would have to be virtually restructured and got sold and re-emerge as kind of businesses with mostly digitalized form. Then there are, of course, a lot of other businesses where the hit might be temporary, and therefore they have the ability to recover and can come back, and maybe after some time they can nurse and they can repay and service their loans going forward. And therefore, in my judgment, and that's my considered judgment, the decision to sort of totally suspend IBC and provide wholesale moratorium were perhaps not as business friendly and bank friendly decisions and conducive to the healthier resolution of the businesses in the country. I would have preferred that the decision to grant moratorium and the decision to take it to the IBC or not take it to the IBC, considering the true nature of a business, is left to the lender. They are the principal party affected. Now, government as a policy maker has an extremely important role to play, and that is what is reflected in a very good design of the IBC which we had in 2017. But government as a policy maker took a decision saying that no, you bank will not be allowed to take it to the IBC. It also gave, which the other panelist was also brought out very rightly, that the businesses who consider themselves as having become insolvent, they realize themselves that they cannot revive themselves, and therefore they would have gone to the IBC to be declared insolvent and to move on. They have been denied access. So I believe that we should not have gone for this kind of wholesale suspension of the IBC. We should have adopted a little more nuanced approach, give this authority to the banks. Unfortunately, what has happened is that we are the banks are the principal party, but the decisions for the banks are being taken by other than banks. And it was said that no, take it compulsorily everyone to the IBC. Now they're being told that don't take anyone to the IBC. And this kind of sort of extreme positions in policy shift perhaps are not appropriate. This would hurt us badly. You have seen the bank credit growth, despite the moratorium interest and other things having been written into as the fresh loans, the growth has been only 5.5% to 6%, whereas deposits are growing at 12%. This kind of policy view has made, to my mind, in my judgment, the bankers totally risk averse. They will suspend further loans. Their access to IBC has been denied, and the response from them would be that they would not provide much loans going forward. And secondly, the entrepreneurs, it was also mentioned, the real estate and others who are broken businesses, they are now being sold or forced to sell their businesses outside the IBC for much less valuation to other businesses, because they don't have a competitive auction-driven avenue available, and you are seeing forced kind of sale of the existing businesses by them. So I think we should take a little better view, a view which allows the businesses to be, banks to be in the primary seat. Let them take those decisions, whether to take to IBC or whether to restructure, which has been done, or otherwise bilaterally settle it. They are the lender, they should be in charge. And I think I'll stop at that, saying that we should respect and we should adopt the policies and the policy framework which goes into the instruments like IBC, which are very powerful instrument, to be such that which preserves the real value of the business not a covered or a sort of put under the carpet kind of the value of the business. That would be in India's real interest. Thank you very much.
Shig, as always, it's a pleasure listening to you. And I thank you for the points that you have brought up. I have myself been thinking that this is 6 months' time that we had. Can we refine our IBC? Because many things that were happening in IBC before that, and we were in the midst of things, could not be changed. We are very fortunate to have Mr. Sau with us. He is the one who is really riding the wave, and he is on the frontier. So, Mr. Sau, we look forward to your views, and please address us and share your views about IBC post-pandemic with us. Mr. Sau. Rajesh. Dr. Rajesh, I can't hear Mr. Sau. Is everything okay?
Sir, just wait for 1 minute, sir. Mr. Sahu has disconnected. So we are trying to connect.
Yes. Okay, sure. While Mr. Sau is getting connected, I can share a few thoughts. Of course, even I'm worried that with the growth rate taking a plunge, the spurt in these issues that will come up into IBC will be massive. And though there is a moratorium sort of, but I'm not very sure how it's going to pan out in days to come. The other worry, which has partly been flagged by other panelists, and I'm worried too, is the misuse of this lockdown period or the moratorium. And how do we ensure that this misuse does not happen? And I think that is where Mr. Garg's concerns come in and are very relevant. He's articulated them so well that these are the issues which we need to really worry about. Other than that, of course, we all know that this is one of the best things that could have happened to the Indian banking, and it has brought some teeth back into the Indian banking. But then settlements, as Mr. Garg said, happening outside the system are also a cause of concern. So I am myself of the view that IBC has to be a little more nuanced now. Fortunately, we have time, and if we could take care of that part and also ensure that we are in a very, very different situation. When IBC was trained, we were in normal circumstances, but now post-pandemic, when IBC has to be implemented, we are in a very different and unique situation. So all these issues become relevant, and Mr. Sahu is in the saddle, and let's go straight forward and meet him because we are running out of time. Dr. Sahu, we are looking forward to your thoughts. You have heard most of the panelists. We are really looking forward to how do you want to address those concerns, as well as your original thoughts that you would have planned to share with us today. We all know you are in a very challenging seat, and we all know that post-pandemic this is going to become far more challenging. We are aware of that. We are looking forward to hear your thoughts, please. Dr. Sahu.
Thank you, Professor Singh. Respected Dr. Hiranandani, Mr. Garg, my distinguished panelists, and my dear friends. I must thank ASSOCHAM for giving me this opportunity to speak to you today. Unfortunately, I lost the connectivity. Just now I came back. I think I missed whatever you discussed. But let me tell what I would have otherwise told. So today we have a kind of strange problem in hand. When IBC was not suspended, many of us had a problem with IBC and we wanted suspension, even termination of IBC. Many didn't want to use it. Now that it is suspended, some have problem with the suspension and they are asking for a reinstatement. Let me tell you a story. Two school-going friends had a crazy idea. They rounded up 3 goats from the neighborhood and painted the numbers 1, 2, and 4 on their sides. They let these goats loose inside their school building. The next morning, when the authorities entered the school, they could smell something was wrong. They soon found 3 goats, but they were worried where was the goat number 3. They spent the rest of the day looking for goat number 3, but they could never find simply because it didn't exist. For some of us, absence of something is always larger than the presence of many things. What has been suspended is a very microscopic keyhole surgery that has been done under IBC. But it is believed that entire IBC has been suspended or complete ban or prohibition is there. Let me give a little context to this. Insolvency is essentially an outcome of market forces. So insolvency law expects that the market should find out its solution. Of course, they need to be facilitated by law, by the ecosystem, by NCLT, IBPI, IPs, all that. But essentially, we believe that this is an economic problem. It has to be sorted by the market participants, and also we believe that economic laws are generally empiric. They evolve through experimentation to meet the emerging needs and to remain relevant to the times. In fact, in one of the matters, in several matters, Honorable Supreme Court has reiterated while dealing with IBC that denial of right to experiment is fraught with serious consequences to the nation. We have been experimenting this law. As and when we find a challenge, we endeavor to solve it. The Insolvency Law Committee, a standing committee, continuously reviews the implementation of the code to identify the issues impacting the processes and make recommendations to address them, believing on the true adage that the road to success always remains under construction. The code has witnessed 5 legislative interventions to strengthen the processes and further its objectives in sync with the market realities and not deviating from the core of the code. That is, the primary objective of the code is rescuing the lives of the companies. Repeatedly, it has been told that the first order objective of the code is resolution. Second order objective is maximization of value of assets of the firm. And the third order objective is promoting entrepreneurship, availability of credit, and balancing the interest of stakeholders. And this order of objectives is sacrosanct. So this essentially means that the law has to remain firmly grounded to the realities of the market and rescue the firms. Wherever there is a way to rescue it, it must rescue it. The whole focus is that it must save the life of a company in distress, and it empowers creditors to rescue their company when it experiences a serious threat to its life. It has given a kind of threshold to the Committee of Creditors, 3 important powers, which was not there earlier. It can take or cause a haircut of any amount to any or all the stakeholders required to rescue the company. This was not there earlier, and whatever the Committee of Creditors does, if approved by the National Company Law Appellate Tribunal, is binding on everybody, including government and any authority under any law. The second is that it seeks the best resolution plan from the market. Unlike the earlier mechanisms that allowed creditors to find a resolution only from the existing promoters. All earlier mechanisms limited that flexibility. And third, resolution plan here is a very comprehensive, can provide for anything and everything, including change in management, technology, product portfolio, acquisition, merger, amalgamation, strategies of turnaround, business model, restructuring balance sheet, sale, disposal of under business undertakings, and it provides a competitive and transparent process that identifies the person who is most credible, best placed to rescue the company, so that the life of the company is sustained. Now let me fast forward to the fifth amendment, fifth ordinance that happened about a month ago. All of you know that we are passing through very, very unusual times when protecting lives has assumed utmost significance. And this in turn requires us to protect the livelihood, which further requires us to save the lives of the companies. Companies are engines of growth. They are a hope of prosperity for the prosperity. They provide goods and services. They provide employment. They provide livelihood. They have an organizational capital over and above their liquidation value. So closure of a company destroys that hope, organizational capital, and therefore it is necessary to rescue a company from premature death and nurse it back to the normal life. In this background, given that the main thrust of the insolvency law is rescuing the lives of the companies, and economic matters require experimentation, so another round of experimentation happened with the last ordinance. Usually, in the normal insolvency framework, the code pursues two complementary strategies in case of stress, namely rescue a viable firm and liquidate an unviable firm. This is complementary. You don't have, these are not competitive. You start the process of CRP. If you can rescue, do it. If it cannot be rescued, then move on to liquidation. So rescue a failing viable firm, unviable one. This is what happens in normal times. Most firms which were viable till recently are reeling under stress today. If all such firms were to undergo insolvency proceedings, many of them would end up with liquidation for want of white knights to rescue them. And upon such liquidation, the assets would have distressed sale, realizing FCML is little. Consequently, firms would have premature death while nor maximizes the value and hence not consistent with the objectives of the code in the current times. So this traditional model does not work at this point of time when every firm, every industry, every economy, and the entire world is under stress. If one airline, someone talked about the restaurants, airlines, if one airline has to be rescued, there must be another viable airline which can rescue this drowning airline. So this called for experimentation that when these twin remedies, complementary remedies translated to two competing options, either you have this or have that. This is the situation we are confronted. Either suspend the operations of the code or let it continue to operate. If you adopt the first option, that means you will fail to, if you suspend the operations of the code, you will fail to liquidate an unviable firm. This mistake can be rectified in the following quarter, in the following year. But the second option, that you operate the IBC in its normal form, that will liquidate, which mistake can never be rectified. So rescuing a viable firm is far more important than failing to liquidate an unviable firm during the current times. However, both the options have attendant consequences, and both have to be, and both of them have some unintended consequences also. So what was required was that let's have a middle path, well calibrated middle path, suspend some of the elements. The ordinance brought in section 10A that prohibited filing of applications only for the purposes of CIRP. It did not change even the definition of a default. It did not anyway absolve the obligations of the debtors. No other law was touched, and even under IBC also, every aspect relating to default remains untouched except that you cannot initiate a CIRP for a default, and you cannot initiate for what period? You cannot initiate CIRP for a default arising on or after 25th March for a period of 6 months or such further period not exceeding 1 year from such date. So such default, however, is not excluded, as I told you, from the definition of a default under the code. It remains a default for all purposes under the code except for the purpose of initial CIRP. And this section further clarifies that applications for initiation of CIRP can be filed for the defaults committed before 25th existence. One can file. If a default comes up into existence after COVID period is over, one can still in. But if a company has not defaulted earlier at all, for the first time it is defaulting after 25th March, only that much. Imagine that man, because of an extraordinary circumstance, this obviously means that this set of companies are experiencing stress for the first time only because of COVID, because they did not have this stress earlier. Only such companies will be prevented from being forced into insolvency proceedings because of the unprecedented situation, force majeure situation. But sometimes people argue that, and remember that there are 10,000 plus applications already filed, pending, waiting for disposal by the NCLT to initiate CIRP. Those are not affected. 3,000 CIRPs are ongoing, those are not affected. 1,000 liquidation proceedings are ongoing, they are not affected. Another 1,000 voluntary liquidation proceedings are on, those are not affected. So what is affected, as I told you, is a keyhole surgery. Unlike the rest of the world has gone on a large scale suspend everything, no filing for next 6 months, 1 month. But this has been done only the default first time arising during this period. But there has been arguments that it's possible that one company who never defaulted earlier, defaulting during COVID period, but it is not on account of COVID, but because of some other fundamental reason. There could be such a rare case who never defaulted, defaulting for the first time. But if we get into that to distinguish which one arose on account of COVID, which one arose on account of some other reason, we will simply lose years fighting legal battles. And as I told you, if there are very such a rare case, let that rare case have the benefit, but let's keep it simple, avoid disputes, and let's move on. There has also been some other changes. There was a question I had in the very past 2-3 minutes of discussion, but then I got disconnected about the why suspend section 10. Section 10 is a voluntary option. Please look at this law. Why did we bring this law? I told you Committee of Creditors has Trishul kind of power, because Committee of Creditors is in the position, this is called creditor in control model. They decide the fate of the company, equity value is lost. This is what the insolvency law did by setting the balance, by balancing the rights of the stakeholders. We had all along a model called debtor in possession that we wanted. We consciously moved to a different model where we gave, as long as equity value is there, equity guy will call the shots. But if equity value is not there, then creditor will decide the fate of the company. If that is the case and you say that which was brought in by this law, we would disturb that balance to say that only debtor will initiate the cases. That means debtor will initiate which are the worst cases. Where there is otherwise good case which can give better outcome to creditors, those will not come in. You will tie the hands of creditors and say that debtors will do this, will go against the basic principle of the law, which has a balance the rights of these two sets of people. That balance cannot be distorted. But there can be ways still to address the problem. I think someone mentioned, Dr. Hiranandani mentioned about pre-pack, MS. The world has moved. If you look at the World Bank, IMF papers, how they have moved, and we are not also doing something greatly different from them, though as I told you, we have done a little more keyhole kind of a surgery. But moment everyone is having a path, given path, where there are considerations of coming up with innovative ways. When we started the code, we did not have any experience of such a modern insolvency, proactive, incentive compliant law. So we naturally started with something kind of plain vanilla options. But we at that time also believed, and there were enough indication in the Bankruptcy Law Reforms Committee as well as in the IBC code. For example, at that time we thought that we need a cross-border insolvency law, but we are not able to provide right now. Let's provide a skeleton line, section 234, 235, enable bilateral arrangement, but in course of time we must move. If you look at the report of the committee which Mr. Bhupendra Yadav chaired, that told that yes, you have to do something more. Pre-pack, BLRC debated on pre-pack, but told that let's wait for a while, it requires further debate. Let's move ahead, start with the plain vanilla things. And I would particularly invite your attention in one of the very important talks of Mr. Arun Jaitley. In initial days, he had told that with the kind of experimentation we are doing, we are soon about to reach a kind of honest debtor and creditor relationship. Very, very fast resolution plan we had, which anticipated, which brought in the first amendment, which has become famous as section 29A, that prohibited what happened in the first resolution plan approved under this law. That was in the case of Synergy Dure Automotives Limited. Financial creditors took 94% haircut. The firm remained with the same set of people. Nothing happened to them. This was not acceptable at that point of time and even today. That is what brought in section 29A, and certain people not having credible track records were forbidden to participate in the resolution process. So since then, the experimentation is going on, one after another. New features are being added. Honorable Finance Minister has recently announced, I think about a month or 1.5 months back, that there will be a special insolvency resolution framework for MSMEs. There also, that will happen within the frame of IBC. Every other country has some kind of a special dispensation for MSMEs, not that there is a completely something outside the IBC. And not that IBC or we are advocating that all resolutions have to find a place within the IBC. Mr. Raman mentioned in the beginning that IBC is just another competing option in the hands of the stakeholders. If you find IBC serves your interest better, please use it. But if you have other options, you debtor and creditor sit across the table, find out a solution, please do it by all means. Please use the prudential framework of RBI. If you are interested in the recovery, you have other options open, many options open. Only when you are interested in resolution and you find that IBC is the best of the resolution in the menu available to you, please use that. So now there has been substantial work on having a framework for MSMEs. In the world, MSME is a part of the normal insolvency framework. It's not outside insolvency framework. With this, but there are some special dispensation, some relaxation. For example, in MSME all over the world, and that is what World Bank also recommends, that during resolution period, they will be under debtor in possession, but no way compromising the rights of creditors. Like Section 28A, the major decisions about the company, that would have to go through the approval of the Committee of Creditors. Resolution plan have to be approved by the Committee of Creditors. So there can be some special dispensation, but without disturbing the basic structure of the code. Pre-pack is a similar thing. Pre-pack in America, they provide under the law. In UK, it has come up by practice. Today, no law prohibits the stakeholders to have a pre-pack on their own. UK did it. They call it SIP system. That is a guideline for the insolvency professionals. That didn't come from any authority under any law. So nothing stops our stakeholders to do pre-pack or resolution. And it is not also a good idea always to ask the state, please give the framework, we will adopt that. And then whatever state will give, it will not be flexible, it will be rigid, it may not meet all your requirements. Ideally, market should find its own solution. But nevertheless, government has set up a committee to give a pre-pack framework. We expect the report of the committee to come by the end of this month. But if this has to be done under law and not by market practice, it will require an amendment in law. Several other things are going on, including group insolvency, cross-border insolvency. For individuals, a fresh start process, the work is on many fronts. But I think that insolvency law has to remain focused on within the basic core. Its focus has to remain the rescue the company, and it must continue to serve the economy, because if it does not serve the economy, we don't need bankruptcy law. Bankruptcy law is needed to serve the economy, and we should do that. With this, I'll conclude. Thank you, Professor Singh, for giving me the opportunity. Thank you.
I must thank Mr. Saul. You really cleared lots of doubts in your presentation. I like the word keyhole surgery. So that means that it was in its very first attempt a laser beam work which was done to basically hit at those cells which could have been in trouble or could be causing trouble. I like the philosophy that you mentioned, that the first and foremost work of the IBC is to ensure that the firms survive. That's really like a doctor, and that's really in a country like India, where setting up a firm involves so much of labor and capital, and not letting a firm die is not only a very important economic objective, philosophically also in a country which is demographic so rich, it's important that these companies are ensured that they survive. I think this has been a brilliant talk, a very informative talk, and a very, very genuine presentation by Mr. Sahu. We must all thank him and give him really full of gratitude for this presentation. Now, because this is a 2-hour conference and the next segment of this conference has to start in the next 6 minutes, I'm taking this privilege of the chairman of the meeting to forego the question answer session, because as it has evolved, many issues have been already answered. So I'm taking that privilege, and I would like to once again thank each one of the panelists, especially thank Mr. Garg for a very well prepared and researched talk that he delivered, the special address. Also thank Mr. Sahu for a well prepared and well researched talk, as well as in a way answering the questions that came up in the panel. I also thank the audience who have taken their time off to listen to our panel. Once again, thanks to everybody for joining us. and making this discussion a success. Thank you very much.
Thank you very much.
Thank you. Thank you very much.
Dr. Rajesh, over to you. I know the next session has to start.
Okay, thank you so much, sir. Anil sir, over to you.
So thank you very much. It was a wonderful session that we all have witnessed, and we have also heard Dr. Charan Singh and Mr. Raman and Dr. Sahu, and it was concluded very well. It was a lot of hope for all of us. See, I definitely welcome everyone for the session 2 of this this National E-Summit organized by ASSOCHAM. So special thanks to ASSOCHAM for organizing such events. Session 2, I would try that it would also be as exciting as session 1 was. Of course, the session 1 was definitely, it was moderated by none else than Dr. Charan Singh, and it was concluded by the lawmakers. Dr. Sahu was there to conclude the session. So it was wonderful to hear all that Dr. Sahu said, the keyhole surgery, and that actually means that nothing, no damage has been done to the entire law. It was only one hole was done, and that hole was required at particular situation. So I have to my understanding today, the subject of session 2 is very, very important. It's basically the liquidation as the last resort, and also as a silver lining for the entire economy, for the insolvency law. Before we start the discussions, I would like to introduce all the eminent speakers today with me. And since it is my pleasure to introduce all of them as a moderator, I'll start with the Ankur Srivastava. Ankur has recently joined as the co-chairman of the National Council of Insolvency and Bankruptcy of ASSOCHAM. And welcome, Ankur. It would be a very, very good pleasure to work with you in the National Council of ASSOCHAM. We have Sahil Narula, who is an expert in valuations. He is the managing partner of RNC ValueCon LLP. We have Mr. Arun Saxena. He is the managing partner of Saxena and Saxena Law Chambers. We also have Shri Ishtiaq Ali. We have a lot of interaction, Mr. Ishtiaq Ali, with you because we've been sharing a lot of dice. He's a founder of Orbit Law Services. He's into project advisory. He's been a banker. He was earlier working as a law officer of the bank, and now he actually has a practice. We have Mr. Rajiv Sinha as a Chief General Manager of IDBI, and of course, a Chief General Manager of IDBI Bank would have all the experiences of handling IBC, project financing, and he also had the credit of handling international assignment. We have Anju Agarwal. Yesterday also we were together in that webinar of Insol. Anju is heading the restructuring practice of ASC Group. She is an MBA. She's an insolvency professional, and she's working on many cases as an insolvency professional. And probably also she would have many answers and questions on the liquidation process of various companies. Mr. Sunil Gupta is from Resurgent India. He's a cost accountant, MBA. He has an industry experience, and he actually handles the complicated finance cases. So with this, we can start our discussions as the liquidation as the last resort, and also how it becomes the silver lining, why it is required also. I think the Dr. Sahu has already concluded in the last session, which we might even deliberate a lot, but ultimate conclusion would remain the same as Dr. Sahu has already given. Dr. Sahu has already said it is very, very important that we should revive for a company which has got a viable business. And it is also very, very important that we should liquidate a company which has no business. So this is the one-liner conclusion of the liquidation process. See, while we say that the liquidation is a last resort, I would also like to say that yes, there are a lot of opportunities which has been provided. A lot of opportunities has been provided in the law, which is for reviving the company, which is for resolution. For example, when we say there are about 8 or 9 opportunities, one opportunity is when the default happens. If we would like to see that if anyone is not speaking, the mic should be on mute, because there is a noise from background. If you can just check whether your mic is mute or not till the time you are speaking. Yes, I think it is controlled now, so there is no noise. Still, there is a noise coming from background. I would request everyone to check. All the participants can't do this because it is only from us only. There is some mute is required. So the first opportunity that we get is when this default takes place, and the law provides for a notice, 10 days notice to any creditor, any of the creditor. At that stage also the settlement can be done and the insolvency can be avoided. Second stage is when the petition is filed and the order has not been passed for CIRP. At that stage also the default can be settled and the insolvency can be avoided. Third stage is when the CIRP is started, and before the committee is constituted, then also the application can be made for withdrawal of CIRP. So if it is not possible to settle and cure the default within the 3 first opportunities, then the 4th opportunity is when this committee is constituted, but in that particular scenario 90% voting is required, so the CIRP can be withdrawn. CIRP can be withdrawn by 90% vote share if the default can be cured. See, now even at the CIRP stage, at the CIRP stage 1, CIRP stage 2 is also there, like this is 90% voting. Now, if during the CIRP stage also, if the promoters if the company is MSME, and they can definitely participate in submission of a resolution plan. So that's another opportunity with the promoters to resolve the default and revive the company. So in case the promoters are not coming forward or the company is not MSME, then the opportunity is available with the public at large to revive that company. The public can assess the business, the company, the public can do. So for all possible due diligence, if there is any business model, the public can revive the company. If the public is also not able to revive the company, then the company goes into liquidation. So, and even during the liquidation, there are 2 options. One is Section 230 of the Companies Act. That's an option available for anyone who submit a resolution plan. And then the second is that the liquidation as a going concern. Liquidation as a going concern also revives the company, revives the business, continues with the manpower, saves so all this is basically when we say that the liquidation is a last resort, that actually means that we have 8 or 9 opportunities to find a resolution for the company. So definitely we all can understand, if the resolution is available, that means that the definitely resolution would be found. But if the resolution is not at all available, even the Dr. Sahu has said that this committee of creditors have actually got threshold 3 powers. One, that for revival of the company, they can even hand it over to the promoters in case it is MSME. They can have any kind of haircut. That kind of power was not available earlier. But then see, this is if that is also not possible, then that exactly means that the best of the resolution plan can be accepted from the market. If that is also not possible, liquidation is the only option. So with this, I would like to start the discussions, and I believe I'll start from Mr. Ankur Srivastava, who is my co-chairman. See, what is your opinion about the liquidation as a last resort, or the how do you find that it is a silver lining? Because you have a lot of experience of restructuring. How do you find that the restructuring is better, or even the CIRP is better? So I think you can provide your opinion on this.
Thank you, Anil ji. As you rightly said, that the liquidation is the last resort or the silver lining. And there are various stages which are from resolution applicants or the prospective investors have during the CRP process where the company can be revived. Of late, when the IBC was started, so it was thought that 180 days period will be sufficient, then the 270 days period timelines, 90 days extension, and within which the CRP process can be completed. Over the period of time during the last 3-4 years when the code is in the implementation, the general experience is that due to various reasons, including the legal issues, the entire process is not able to get completed within that period. So to maintain the sanctity of the timelines as well as to revival of the company, because the aim of the IBC is not the recovery, which has been reiterated by the various judgments. It is the revival of the company, and if it's not possible, then only as a last resort, you should go into the liquidation. Then thereafter in 2019 amendment, the provision has been made, like you said, where the 90 days period window has been provided, even when the liquidation order has been announced, the company can be sold as a going concern or on the asset basis. So this give again the chance beyond the CRP period to the prospective investors or even in the some cases the promoters of the company or particularly the SMEs, so that they can again put some plan, they can still revive the company. Because if this is the last opportunity available to them beyond the CRP period, beyond the extended CRP period, within which they can go for the revival of the company. So this is a very good opportunity given to the promoters or the resolution applicant, and particularly within this scenario when the COVID is there, a lot of timelines have become sort of immaterial in the short term because all the exemptions and everything are available now. Even one of the recent cases of the where the FinQuest, they have also allowed the resolution applicants to change the payment timelines. So this gives certain flexibility to the investors, to the employees of the companies and the others to revive the company. And ultimately, if you have not take up avail the opportunity during the period, this is the last. And we should, and it has also given the flexibility in terms of you go for the mergers, you can go into the scheme of arrangement under the section 230. So there is a lot of flexibility within which this 90 days period provides. So as the rightly the topic is that this is the last resort where you can revive or survive the company.
Very good, Ankurji. So I think this is a very, very nice, the kind of subject that you have raised is the timeline. So the timeline, which originally was 2 years, and finally it was reduced to 1 year. Now we are supposed to do this liquidation in 1 year, and in case we don't do that, we have to submit an application for extension of time, and we have to justify why this extension is required and why have we not be able to conclude the liquidation process. I think this is a very, very important issue today. We have Arun Saxena ji with us, a person who actually is practicing IBC as a lawyer. So Arunji, can you explain us how can the insolvency professional who's been appointed as a liquidator can finish liquidation in 1 year? What are the hurdles in finishing the liquidation in 1 year? Can I recover my sundry debtors in 1 year? And if yes, under what law? So in case you have experience of handling a lot of legal cases, so can you just highlight some of these issues? This 1 year period, is it really possible to comply with? So please unmute yourself. Please unmute yourself.
Thank you, Anilji. And the question put up before me is whether liquidation process can be completed within 1 year by the liquidator or during the extended period of another 1 year. See, this is a very important question because the object of IBC, one of the object was to do the resolution and the litigation within the frame. And due to certain reasons, time frames were not being maintained. And reasons, so far as I am not talking about the CIRP, because I have been asked to give the reasons for the liquidation. So liquidation RP faces a lot of problems in recovering the assets. Some assets which company has, they are non-existent also. Sometimes assets are in such a manner they cannot be sold, and it takes time for RP to get the realization of all the assets. And most of the cases I have experienced, the liquidation could not be completed in 1 year, even 2 years also. So, and if you come in present scenario, during the pandemic and after the pandemic, it will be very difficult to find a buyer for the assets, for the to the resolution professional or liquidator for the sale of the assets. The rates are being down, valuations have been decreased a lot. So first of all, the liquidator has to get the revaluation of the assets, fair value or liquidation value, so that the benchmark can be fixed for realization of the assets. Second is very important is non-cooperation from the corporate debtors. Sometimes corporate debtors, I have experienced the cases where corporate debtors are not able to identify the assets also. The assets in the balance sheets are not available to the liquidator. What to do? So then liquidator has to go for the making the applications before adjudicating authorities, NCLT, for directing directing the ex-directors to make available the details of the assets. So first thing is it is very difficult to get the true buyer for getting the maximization of the value of the assets within this limited period of time. Number two, it's a non-cooperation. Number three, there are few technical problems or difficulties faced by the RP, like they are not able to find the assets. They are not able to identify the assets. Assets are in such a shape they cannot be sold out. Then it will be sold out as a scrap or as a residual value. So the valuation plays very vital role in case of this liquidation process. And according to me, in this present scenario, the revaluation is ought to be there for the fair valuation and the liquidation value. Unless this is done, the liquidator or RP will not be able to complete his or her job by selling the assets and getting the company or corporate debtor liquidated. So these are my some of the views on your questions. Thank you so much for giving me opportunity.
Thank you, Arunji. Thank you very much, Saxena sir. So I think the very, very important question, which in fact, I also wanted to raise, so you have already raised, Arunji, this question, like the information is not available to the insolvency professional, to the liquidator. The promoters are not sharing the information because they are not interested in the company anymore. The liquidator would probably, even if some employee is there, which can be retained by the liquidator, that employee would still remain loyal to the old employers and would not share information with you. So in this scenario, the biggest role which comes to the liquidation processes from the valuation fraternity. So we have a representative with us from valuation fraternity, with Sahil Narula. Sahil, the very like pointed question to you is that how actually for a valuer also is it possible to do physical verification of the plant and machinery stocks, and then do a good valuation so that the liquidator is not depending upon the false books or false fixed asset register, which has been kind of padded up for various objectives of the promoters. But the real assets which actually are there has to be seen by the valuer and has to be reported by the valuer. See how the valuers are able to do that, what kind of technology that they are adopting, that also is very important in this present scenario. Sahil Narula.
Sure. Thank you so much, Anilji, for this question. And so to answer this, I would like to kind of break it up into two parts. I concur the views of Arunji when he mentioned that there is non-cooperation from the corporate debtor as far as the availability of an asset listing or maybe data or cooperation is concerned. So that is definitely a challenge. But what I would like to give it a thought is that there are probably two kinds of assets. One is wherein there were a pre-NCLT regime, the assets which have been migrated from a DRT or a SURFACE or a BIFR regime. So these are typically your old assets which have minimalistic data available primarily because they are old, and hence they have been transferred to an IBC regime. So these today take up probably a bulk as far as the numbers are concerned in the IBC numbers are concerned. So these cases, primarily the information which ideally should be available in the form of an asset register, fixed asset register, or an asset listing are hardly or rarely available. However, as one of the primary responsibilities given to the valuer is to carry out the physical inspection of the assets as well as the inventory. So what happens in such cases is that a valuer carries out a physical inspection of both the fixed assets as well as of the inventory. However, there is a remote possibility or a rare chance that these assets actually tally with their books of accounts. So this is one challenge that is faced at the ground reality, wherein there is a physical inspection possible, but they may or may not tally with the asset registers or what the books of accounts reflect. Second categorizations are probably the newer companies who are probably going concern or were operating or are in an operable stage, but because of the stress in the system, they have been admitted into IBC. So in these cases, what we have seen, and these also probably would be lesser in numbers, but could also be larger in value. So what is typically transpired is that here in these cases we see that there are streamlined processes followed in the corporate debtor. They were audited, a physical inspection was carried out, and hence the information made available to the valuer, made in the form of a fixed asset register, made in the form of an asset listing, is made available, and hence the reliance on the data of the corporate debtor then becomes a possibility for the valuer as well. So I would not deny the fact that there are challenges. Yes, there are, and there shall continue to be challenges, but probably by being more humane to the team of the corporate debtor, playing a balance between the erstwhile promoter and his team, managing the operations of the existing resolution or the liquidation professional, we have to play a game of taking and extracting the maximum data available both from the corporate debtor or from the statutory authorities, wherever to the best of the extent possible, and basis the information available, we need to carry out a valuation and an inspection adopting these different methods.
So thank you, Sahil. While you are saying, so we all understand that all the valuers are working very hard. My experience says that I would advise, because I understand there are more than 500 people who are presently connected with us. So I would share my experience. Whenever you get the valuation done to all the liquidators, I advise, I give my experience, please accompany the valuers, and please see whether the proper job has been done or not, whether the things are properly covered or some of the things are left by the valuers. Ultimately, the responsibility might come on you that you have not been able to see the valuation report properly. If you are not able to go, then send your team so that the team should go there. The team should understand the unresolved questions of the valuers, and those questions need to be answered, because the valuers also may not know some of the names of the machines, because see, today they are valuing a power plant, tomorrow they might value a cement plant, and then they can go to a chemical plant, and then they can go to a store of retail. So that's something which is very, very difficult for each valuer to understand. So if the company employees are available, it's okay. If the company employees are not available, you should also have the fixed asset register along with you, and your person should visit along with the valuers. So that's very, very important, because see, the liquidation is all about valuation. In the liquidation process, if the valuation is not correct, that means that your liquidation process will get spoiled. Coming back to our main issue, which is the
Anilji, sorry, I have one more point to make here, if I may, in continuation to your observation. So I agree and concur with your opinion regarding the verifications, and I would also like to add the point of your asset memorandum. So now what has happened is that as part of the work, an asset memorandum has to be prepared by the liquidation professional. And what happens, typically is that asset memorandum which is prepared is very different from what your typical fixed asset register or an erstwhile asset listing would be available. Now the challenge that a valuer faces, and which I would like to highlight, is a fixed asset register is nothing but your periodic purchases which would have happened erstwhile, and it may or may not give a description of an asset in entirety or either in parts. So typically what a valuer has to do is he has to create his own asset listing, which ultimately a liquidation professional uses as an asset memorandum. So there are a couple of challenges which a valuer faces here. Is about ownership. So today, if a question is to be asked that a books of accounts has a figure of say 100, whereas your asset listing or asset memorandum has a figure of say 60, where is the balance 40? So this is a very common question which is posed to the valuation firms. So the challenge here is primarily is because there is never an apple to apple map, or in especially companies which are a pre-IBC era and which have migrated from your DRT or BIFR or SURFACE regime, and hence for a valuer to correlate that from the books of accounts is extremely challenging. However, what a valuer can definitely do and should do is that carry out a physical inspection by deploying a team with ideally presence of a corporate debtor and liquidation professional team members, or in isolation otherwise as a plan B, and specifically make a list and ascribe specific values against that list, which subsequently may be a part of an asset memorandum, which shall then make it easier for a liquidation professional also, and which may become a base list for the future liquidation process.
Yes, I think this is the one guideline that we can give to all insolvency professionals. We come back to our main issue, liquidation as a last resort. I definitely would like to take the views of an experienced banker that we have with us, Mr. R.K. Sinha, Rajiv Sinha ji. So, Sinha Sahab, I think we would like to understand how the banks are trying to see whether this is the only option available now and we should push the company to liquidation, or how do you assess whether the company can be revived or company cannot be revived? So how your team takes guidance from you? So I see Mr. Sinha, please.
Thanks, Anilji. Good afternoon to all the panel members and the audience. Definitely, it's a privilege to be on the platform of ASSOCHAM. You rightly talked about, we are talking about liquidation and the silver lining and all these things. In fact, rightly so that you have bifurcated into two parts, that liquidation last resort and silver lining in liquidation.
Yeah.
See, as such, once we talk about liquidation, then I think we are demeaning the crux of IBC, which always has been in resolution and value maximization. So definitely, if we believe in creation, then Liquidation is the last resort. Now, the second word which comes over here, it's a silver lining. As such, it's a metaphor for optimism, means, and the pandemic might have created darkness, but we see stars only in the darkness only. So let us keep that in mind. Sometimes when things are falling apart, they may actually fall, they may be falling in place only. We reach to this last resort only when we find that there is no value left in the corporate debtor. Dear friends, I have been a part of IBC journey since the time RBI first list of 12 cases came out. And I was associated with 4 of those cases, including SR Steel and JP Infra, both having diverse characters altogether. So before discussing the phase of, means post-pandemic, anyway, we are talking about, because we are in the very distressed situation. I would like to bring certain facts, figures, analysis, and lessons and experience, which, if addressed, will enable us to create the silver lining we are looking for the post-pandemic. So I will talk briefly, to start with, I'll just share, since I told you about the RBI first list when we started and what we have learned and how we address going forward. Now we had 12 cases in the RBI first list. So 5 of the cases, in 5 of the cases, resolution plan has been implemented and 2 under liquidation. So it means out of 12, means 7 have got their fate. So we know that what is happening to those 7. Now where are the balance 5? So if we see the progress today, 3 of them are under implementation and 2 is still CRP is going on. Now the question arises, IBC talks about the process of 3 quarters, but now it's more than 3 years. Means what it talks about, means where we are, means what exactly we are looking for. I will give you the another fact and figure. Out of approximately, if I go by the IBBI data, 3,800 cases have been admitted and around 900 have gone into liquidation. What does it talk about? Means where we are. Third is, if we talk about the means the cases which have gone into liquidation, majority of them either plan has not been received or COC has not approved the plan. It means either resolution applicant has not seen the value in this or COC felt that there is no value in this one. And the last one which I would like to point out, in the present CRP as per IBBI data, means I think 2,700 CRP is still going on. More than 35% have crossed already 270 days. Now the question arises, when we are where we are losing the value. And, ultimately means when we are delaying the resolution process, ultimately we are losing the value. While we are having such a robust code, why we are often staring at the last resort being the liquidation? Actually, I would divide this entire process in 4 parts. One is that when we file an application in NCLT and till the time it is admitted in NCLT. So this is very crucial because if as such IBC talks about 14 days, means within 14 days the decision has to be taken. But actually, means if when we file, when we take a decision to initiate a CRP, the asset stripping starts from that point of time, where we start losing the value of the asset. Now the second phase is CRP period of 270 days. And the third one is, and anyway, CRP period of 270, but we all are part of CRP process and we have seen all the various litigations and various intricate dispute and all these things. So anyway, we are used to that and we have tried to work out something and we have gone ahead. Now, another crucial thing which I would like to point out, that from the date of approval of COC, when COC has taken a view on the resolution plan, till the time NCLT gives approval. So this period also has become very crucial in the present scenario. And the last one is that after NCLT has approved the plan, till it is getting implemented. So I think, means we are not going to the stage when it is actually implemented, because only if we have implemented the plan, then actually we preserve the value of the corporate debtor. And actually we can really take pride that, means we have done something. So if we analyze and address the issues involved in at various stages, this will largely preserve, this would largely preserve the value of asset. And even if we reach to the last resort of liquidation, still we have value in it, because if you address all these aspects, then definitely the value is there. Silver lining will not come on its own. It needs to be created since the beginning. Now let us talk about the 1 year of suspension period. Since the time pandemic has started, the corporate debtors, primarily MSMEs, have been facing difficulties to survive. RBI and government has come out with various measures to protect the corporate debtors and Indian economy as a whole. We all are aware that during the pandemic, values are getting eroded and capital also getting eroded. Now, point is that means if we have to find out resolution, now what we should do? There could be two things which might be, which might actually come to the rescue of the corporate debtor. Like even in the during the last 2 years, you must be aware that RBI has come out with various guidelines to address resolution of stressed assets. It talks about that if resolution is not found during the certain period, options are given to find resolution under IBC. Now, just mind the language here. There is a very thin line and a hint that the first we need to try and find out the resolution outside IBC, though it can be done upfront also. It just gives a small hint that there could be a value erosion in the prolonged resolution process under IBC. And if no resolution is found, creditors may have to head towards the last resort. Now, what is likely to happen post-pandemic, after 1 year of suspension? If the resolution under IBC framework not found, then the cases are likely to be referred to NCLT for initiation of CRP. Definitely, it depends upon the creditors or it is a stakeholder, means how they try to find out the ways. There could be two things which might be observed. One is that there are some good companies, they could not withstand the pandemic factor, and finally they have become NPA. I'm talking about the good companies. So there are some good NPAs. And there could be, the second one, there could be flood of stress asset, which we have to address. Now, considering the perennial issue, even if suppose today I decide that, okay, post-pandemic, if I have not got any resolution under the RBI framework, definitely, there is a pre-pack also, I have worked out certain things. And finally, I decide to go for IBC. Considering the perennial issue of admission of the case in NCLT, which even may, in many cases, have been delayed for 1 to 2 years, IBC post-pandemic is likely to pose a lot of challenges as far as value preservation is concerned. So during the pandemic period, if we are able to address the issue which we faced pre-pandemic, the liquidation on a going forward basis can be avoided. I would only say that to conclude my talk, I would only say that even if we reach the last resort due to some reason or other, if we have preserved the value of the asset during the entire process, we still will be able to find the silver lining during the liquidation. It is desired that the liquidation process should not result in death of the assets of corporate debtor, and still, if it should not, it should fetch some value to the stakeholders. Now, when see today, if you ask me as a banker, if some stress assets is there, I try to find out various solutions through some various methods. And once we fail, because I know that if I do settlement, I do surface and other things, within 90 days or 1 year or something like that, I get some value. But now since I have to go to IBC, if at all we have to go to IBC, we have to see all the pros and cons, whether it's really beneficial to go to IBC. Now I would only say that at the end that the too many people miss silver lining because they are expecting gold. And let us make IBC not only for resolution, but also for value maximize, and not only for resolution and value maximization, but also for value preservation. So I do agree with our value, the professional valuer who are sitting over there. I was just listening to them. See, the fact is that we don't preserve value. Today we are talking about the the process of liquidation to go smoothly or something like that. But why we are talking about the value when the liquidation has taken place, or we have decided to go to this last resort? Let us talk about the preserving of value since the beginning itself. Even if we don't, if we fail in our approach, we are not able to reach to any resolution, still at least I have that satisfaction that I have preserved the value. And liquidation process itself, it will be a very easy flow for all of us. So it will not be that once liquidation has come, And after that, I'm thinking that how to, means create the value and, proceed further. So I would only say in the last, that value preservation at the end of the process is very important. And if you are able to do this, which has to be thought of from the beginning itself, we'll be able to, revive the, means stress in the economy and, get some recovery to the stakeholders. Thank you.
Thank you, Mr. Sinha. Thank you very much. So I think your focus has been on the value preservation, and I think the one scenario which has emerged from your talk is, let us try to understand what is the kind of average time that we take for resolution. See, we take 6 months time as normal application to the order of the CIRP by NCLT, because there may be some orders which we get normally in 2 to 3 months, and there may be some orders which we get in 1 year. So average time is 6 months time for getting an order from NCLT for CIRP commencement. See, 270 days is the normal average nowadays, and the 270 days is taken as the normal CIRP period, and then the application is submitted for approval of the resolution plan. So the average timing again can be considered as 6 months, depending on the litigation in each case. And feel Mr. Ishtiaq Ali actually would add what is the normal time for getting a resolution plan approved later on. But I would like to say that 6 months, let us assume that the time for the approval of a resolution plan. For implementation of a resolution plan, minimum 3 months is required. Minimum 3 months, because there is a date when we hand over the company to the resolution applicant, and that's in no way it can be less than 90 days. So in total, it takes 24 months. So it can be, in some cases, it can be 18 months, and in some cases, it can be 3 years. So the average time for resolution is 24 months. So this is what actually the talk of Mr. Sinha has finally emerged, that the average time is 24 months. However, the asset stripping is only happening when the debtor is in possession. See, when the creditors becomes in possession of the assets, then the asset stripping is stopped. However, there is a CIRP cost, incurring of CIRP cost that includes the losses, which actually can continue for some time. So that's basically is something which is not avoidable. Even if the company could have stayed in the possession of a debtor, that loss could have continued. Now, if the company has come to the possession of creditor through a resolution professional, so that cost definitely can be reduced. So this is this is one thing very, very important, that the asset stripping is stopped. What I think Mr. Sinha is saying, that because of the delay, the glitter of the silver lining is a little bit of reduced. The valuation is a little bit of reduced. I think I will reach out to two experienced, like one, Mr. Anju Agarwal and Sunil Gupta ji. Basically, just to compare with the other kind of restructuring that you are handling. Anju also is heading the restructuring practice of ASC Group. Sunil Gupta is also doing a lot of restructuring under the Resurgent Group. So how do you handle, I think we'll start with Anju. How do you handle whether this is comparable to restructuring processes, or you still find that the resolution process and then finally liquidation is the best option?
Yeah, thank you, Anilji. Good afternoon, everyone. It's my pleasure to talk to you all here and being a part of this discussion. I will start, Anilji, with two basic things which our panelists have already kind of talked about. Mr. Sinha has talked about a lot about stripping of assets, and Sahil talked about the valuations part. So little bit I would like to add here, and then I will move on to your question and my aspect of silver lining in the liquidation. So, Sir Sinha sir, I think it is very, very important. So not only the stripping of assets is happening once the application goes for initiation of CIRP, it is actually siphoning of businesses, which happens a lot. In fact, so when we were appointed as an IRP in the largest travel operator in India, which had operations in 34, 35 countries. So when we got into the company and we started the CIRP process, we got to see that a lot of IPs, means licenses, which the company had, and a lot of business which they had already siphoned off to that business to their business partners or associates and things like that. So it is very important for the creditors, whosoever is kind of filing the application, to look into that aspect. So may I suggest here, as a resolution professional, and have been working on many companies into different aspects and industries. So there is a provision of interim moratorium once the individual insolvency would be notified or something like that. So there is a provision of interim moratorium. So might as well, can we have that into corporate insolvency processes as well? Because in any case, in the section 7 and 10 applications, the applicant has to refer the insolvency professional. And section 9 also, most of the operational creditors also refer. In very few cases, the insolvency resolution professional is not referred. So that can be done. In any case, NCLTs and IBBI has the ready list for insolvency professionals. So why not? And having said that, we are also working on a lot of pre-packs and pre-restructuring kind of a mechanism, which we are trying to implement here in India as well, like in the developed insolvency regimes. So for the pre-packs as well, we would be looking into that. And in any case, like resolution professionals or some expert onto restructuring would be required to do that. So for that aspect, I think not only for stripping of assets, but siphoning of businesses also, we should look into that aspect. And Sahilji is about the asset verification and the valuation part of it. Definitely not, RPs, whether they are as IRP and RP or they are appointed as a liquidator, they are supposed to do the physical verification. And it is my personal experience, and I would suggest as my personal experience, that definitely the professional team should go into do the physical verification and make a list of it, whatever assets they can see physically there, and actually they should compare it with the balance sheet and the asset list of the corporate debtor and make it a document. So they should actually document it somewhere that we found this much difference in the assets. So at least it has been heard, it has been seen that there was a difference. The assets were not as per the assets list of the corporate debtor or the balance sheet of the corporate debtor. So they should actually do it, and definitely we never ever let go that thing. And in our processes, we definitely do at the time of CIRP also, and at the time of liquidation also, we definitely do each and every physical verification of assets even before the valuer get into the picture. So we do that without fail. We try to do that within the first week of the appointment. So that's what means all the resolution professionals and even the valuers should do that. So whatever material or whatever list is provided to them, they should definitely cross check with that what they have physically verified and what actually was in the list or on the papers. So if they have not found that. Now I would come to the thing like the other restructuring options. So definitely we have SARFAESI, we have obviously in the civil courts, we have different bodies. Say for example, we have RERA for real estate projects. So we have so many mechanisms even now available for any recovery or restructuring purposes. But then we all know that they are very much time consuming, even if today we compare. So I definitely believe that in IBCs there have been a lot of lag or delays in completing the projects or CIRPs and even liquidations. But I think there are certain, because once in the beginning, very beginning, the law itself was at a nascent stage, and there were so many gaps in the law itself, and so many things had to be plugged in. So many ordinances have come, amendments have come, so there was no much clarity, and everybody who was interpreting rules and regulations and law to their own benefit and things like that. And now after in the CIRP, most of the issues have been already I think addressed by the judicial authorities, means from NCLT, NCLAT and up till the Supreme Court. And liquidation now, because obviously liquidations took some time. In initially NCLTs were not allowing liquidations without kind of exhausting all the CIRP period, and they were not allowing COC to approve for the liquidation. So it took some time. So now liquidation has already started on that I would say journey, and very soon whatever gaps are there in the liquidation, that will also be plugged in. And as I have told yesterday also, initially whatever cases come, they were under stress for many years already altogether. So now when the fresh cases will come, now when the I would say that the idea of or attitude of resolution or restructuring would be, common with corporate debtors and the creditors, then definitely it will take lesser and lesser time. As in the very beginning, Sahu sir has always been telling that when the dematerialization of shares have started, it used to take months and months, and now it is just a second's job. It's all online, and you can do it in just a click or something like that. So I'm sure in these processes or in restructuring practice also, those things will happen when the environment is conducive and people are ready to kind of have that mindset that if the business is sick, if they are not solvent, it might as well they say and have a red flag somewhere and start the restructuring process. Now my idea about silver lining in liquidation would start from having a positive attitude towards the assets. So I will not say when a company is going into liquidation, it has already lost all its value. So definitely there is a value. That is why the liquidation has happened, and there are some assets which have to be liquidated now. So there is definitely some value left still in the liquidation. So I would not say that that there is no value left or something like that, and that is why liquidation is happening. And why liquidation is very, very important for the basic principle of economics, that resources are limited, their uses are multiple, and we have to save our resources. So if I take up an example, I will try to explain my point with example. Say for example, UPSIDC is a board who gives the leasehold land for the industries and everything. I'm sure everybody sitting here would know that. So recently they have come out with changes in their policy. They have tabled that, and they have already approved that any industry which goes into SIC under IPC, and they have also used BFIR, although BFIR is not at all in picture now, but anyways they have used that term as well. So any stress assets, so they have allowed sale of the extra land or alternative usage of the land, if at all, and things like that. So why I'm saying so is if we go about all the boards and all the states who give the lands, it's very easy to kind of use the land which is already used in farming or for any other purpose. But I think in every state, 30% of the lands or companies or industrial bodies, industrial setups are not in use. And it is much cheaper to sort of make them work or make them to use, rather than kind of developing a new sort of SEZ or new industrial estate or a new land for that matter, because there is a lot of cost involved in that. You have to create infrastructure, electricity, roads, water, transportation, everything. So might as well, rather than creating new SEZs or new industrial areas, there is always a potential of using this 30-40 locked estate or assets, which can be because sometimes what happens, the lease hold land which was kind of given for some industry is now not viable either, because the product has already been lost its life cycle, or maybe the technology in the company was not good enough or is obsolete. And sometimes it is also possible that that the manufacturing unit is producing much pollution which is not now feasible, because there is a lot of residential things have come up in the vicinity. So what is the possible outcome is that that land or that place or that machinery can be sold, and then that can be reutilized for an industry which is possible now is still in that area or in that environment. So definitely I would say, obviously, and please do not mistake me that I am kind of promoting here liquidation, not at all. As a resolution professional, I will do, or we will do all the endeavors to bring a resolution in the company before taking into the, and in any case, resolution professionals are not the one who decide about the liquidation. It's ultimately, if we do not get an RA, and it is the prerogative of COC who decides to liquidate if we do not have any investor or any RA for the company. So that definitely there is a silver lining, but obviously as professionals we need to be very mindful of that we took or we do every effort to bring in the resolution. And then only if at all. So as I say always, that moving on in life is very, very important in every aspect of our lives. So we should do the same when we work as professionals or we work as kind of business owners. So I think with that, I would like to conclude my thing. Thank you so much.
So thank you, Anju. You actually have raised this issue, which is very, very important, which siphoning of business that you said, which
Yes.
normally we call as phoenixing.
Phoenixing.
And
You only use this. Yes, I remember.
Phoenixing will come back again. So I think with the same scenario, we actually will now reach out to Mr. Sunil Gupta for giving his views about the liquidation as a last resort or any other restructuring options available.
Thank you very much, sir. And I thank ASSOCHAM for giving us this opportunity to be present here. Good afternoon, the panelists, as well as all the audience which are there. And I'd just like to share a few thoughts on and add what our eminent panelists have already shared their views. One is on siphoning of assets or non-identification of assets, which is very important aspect, particularly where the group companies are there. Normally, you have group companies operating in the same segment, and the assets are common, the premises are adjacent. We are finding in one or two cases where the assets of one company, which is under CIRP, lying on the premises of the other entity, which is other group company. Now the problem that we are facing is the operating unit having assets of its unit which is under CIRP, and as we have been discussing that we are not getting support from the CD or the directors for identification of assets. We are unable to identify those assets. So this is very important for the bankers as well as the auditors to clearly identify the assets, and the physical verification which is required has to be done very diligently. One more aspect which I would also like to highlight is that we have not discussed the role of auditors here. There are, in most of the cases, there is a requirement of physical verification of assets, the documentation retention by the auditors, and we are finding that even the auditors are not very keen to share the information which they should have been keeping for the CD. Now, if a physical verification of an asset has been done by an auditor maybe 3 years down the line, so that at least we can start from there. But whenever we are approaching the auditors, they are not very keen to share. And here, I think some regulation has to come up where the auditor has to be made responsible for sharing the information. The third portion that when we were discussing about losing the value, and Mr. Anil Saxena as well as Sinha Saab was very rightly pointing that from the date of application till the date of order or the date of handing over the asset, there is a stripping or siphoning of assets. Now, even after with the commencement of CIRP, we are finding that because of the CIRP cost, lot of lenders and the creditors are bit hesitant in incurring the cost, while they are not understanding the value of preserving the value of the asset. See, the cost versus the benefit has to be understood, and that has to be brought by the RP or the liquidator how to preserve the value. The preservation of value, as Mr. Sinha was rightly highlighting, is very important. I would like to share 2 or 3 things more into I will bring to the panel that, see, there can be a business where we have more than one segments, and 1 or 2 segments may be faring very poorly, whereas the other segments are doing well. as a preserver or the liquidator, we can ensure that we sell those segments and realize a better value to the business as compared to selling in parts or selling into pieces. So that is one aspect that we can we should look into it, and as a liquidator or the RP. And second is the law mandates that the resolution professional or the liquidator should make all effort to continue the operations of the corporate debtor. Now, in this case, there is a possibility that in one of the cases I will share with the experience that I'm sharing, that in one of the cases there was it is a EPC company where they are having some contracts, and for we are getting that CD to operate, and during this period we have realized actually around 15 crores not only from the debtors and executing the contracts, running contracts, but also about 3 crores from the statutory authorities which was pending with them. Now, while continuing operation is very, very important, and the creditors as well as the liquidator has to see where it can find value to it, and that is the silver lining into the liquidation, which has been rightly said by Mr. Sahu in the first leg of our panel discussion. It is important that we exhaust all the opportunity, all the options that Anilji, you were telling about 8 or 9 options which are available to the RP as well as the liquidator. But yes, even if they are exhaustive, we should find opportunities of selling in parts, in segments, so that we can realize higher value and highest value whatever is possible. As far as restructuring is concerned, sir, definitely the RBI guidelines are there, and the CD or the companies can go into restructuring. Banks under this current August 6th circular, banks have been given a lot of power, and any amount of haircut is possible under the restructuring as well. But my point is that again, coming back to IBC, both are not competitive. They are complementary to each other, either restructuring or the liquidation or resolution under IBC. Rather, I would suggest that the code name should be Resolution and Insolvency and Bankruptcy Code rather than just Insolvency and Bankruptcy Code, because resolution is the key or the heart of that the code, not the insolvency. So that is the point that I would like to make. And see, one more idea which we are working on, that particularly in trading companies, there are a lot of debtors which are there. Now, debtors realization may take some time. So, if there are a lot of avenues where we can assign debtors, and we can realize value to it, because if we individually go to realize the debtors, we may not get that value. But if we go and assign the debtors to specialized agencies, then the value that we may get from this, for the CD is better. So now, coming back to what our core panel discussion was, that unless and until we have traded all the opportunities and the silver lining into the liquidation, till such time we should try to operate and maximize the value, not only preserve but maximize the value of the asset, and only as a last resort we should go for a liquidation into pieces, and that too when we are selling the assets. Thank you very much.
Thank you, Sunilji. Thank you very much. I think the most important point that you have raised today, and which is also all the insolvency professionals are suffering, the one that the information is not coming from the auditors. One, they might not even have that information, and secondly, they are not willing to give the information. So something has to be done through the Institute of Chartered Accountant, that the information should be passed on to anyone who needs it, not only insolvency professional, but the information should be passed on to anyone who needs it, and that should be there should be some regulation by the Institute of Chartered Accountants. Definitely, debtor recovery is a very, very large issue. We are suffering because India doesn't have any specialized agencies which are in the business of recovering debtors by way of assignment, because they are not getting the appropriate documents when they get the list of debtors, not even the KYC of the parties. Ishtiaq Ali Saab is a very, very experienced person. I think he is the most experienced amongst all of us sitting in the panel today. Ishtiaq Ali Saab will share his legal experience, how the liquidations has been obstructed by the promoters many times, how the liquidation order has been trailing in the court for about a year, and how this can be amended, how the situation can be handled when the liquidation orders are not even passed for about a year because of various litigations. Ishtiaq Ali Saab, I'm only asking you the question which is legal, because I know that your 100% time is spent in the legal practice nowadays. So you can choose any other question also in case this is not appropriate for you. You have to unmute yourself.
Hello, I am audible.
Yes, absolutely now.
I am audible now.
Yes, yes.
I am audible.
Yes, yes, it is. It is.
Thanks, Mr. Goel, for a nice word. And as far as my experience is concerned, I have no hesitation to say, okay, IBC regime and pre-regime. I work in one of the financial institution in India more than 17 years, from 85 to 2000, and I have handled a lot of cases in BFR, in CDR, in DRT and SURFACE, and of course in liquidation process. And IBC is nothing but a different kind of the law and handling the same situation which the banker faced in the past with a different environment. As far as the liquidation is concerned, there is no doubt about it. Even a last minute's goal is also very important goal for winning the team, and liquidation is also one of the situations where the lenders can hope ultimately, whether we like it or not, whatever the philosophy of IBC is there, in the end lender is more interested in their recovery situations, how much they are going to recover the things, whether it is a resolution process or it is a restructuring process. This is all terminology. Resolution is nothing but a more haircut under the legal regime, and restructuring is nothing but a relief and concession. I am sure Mr. Sinha, I do not know, may not be aware about. In 85, we are doing the relief and concession mechanism because of the NPA guidelines. Ultimately, my restructuring is linked with the NPA guidelines of the RBI. Up to 91, the situation was different. Default was always there, and default is going to be there. Nobody can prevent the default and fraud in life. Otherwise, things will not move. Whatever the philosophy we have. Second is, now come to the question in short about IBC's regime situation for the bankers also. We are too much talking about that it is now shift to, in the asset is shift to in the hand of the, basically with the creditor, not to the debtor. If you look into it, even a bankers is not in a position to put their in fact system in a place where from the disbursement and till the implementation and operation stage, they are in a position to control the assets of the borrower. Though they have a full right, they have a full mechanism is in place, and with all due respect, if they are going to do these things, then even a resolution is possible. Bankers should understand that it is my baby till my money is coming back. It's maybe controlled by board of director. We have a nominee director concept earlier. I was a nominee director in more than 20 and 30 companies in my life. Of course, I have not handled small cases, all the big cases, IDBI, IFCI, and all these cases. And I've seen that in a nominee directors, there is a lot of opportunities for the bankers to understand where the company is going on. Default and IBC and all this is not a solution in the end for business development. This is the situations we are handling it because problem has come up. The first default, now the biggest question in that if first default is there, banker is in a position to go IBC also if they understand the business of the company. As far as the timeline is concerned, Mr. Goel, you may or may not agree. Timeline, this is not a rule you can apply in every sector. And Mr. Sinha, I'm sure you will understand much better than me. Every sector, every company have a different mechanism to control the things. I have handled manufacture, I have handled civil aviation sector, I have handled shipping, I have handled lot of sectors I handle, and I'm handling right now in my life. And my whole life is based on financing and recovery and surface BFR, CDR, all this life and handling share. And you believe me, the liquidation process should start with the mindset with the day one CRP start, as Sinha has rightly pointed out. Asset protection is start day one when the disbursement has been made. Whether you are talking about the signing of the business, and Sinha will agree, 50% in cases signing of the fund. Whether banker admit it or not, signing of the fund. Not if money is not going to the project, cash flow cannot be in fact coming from the project. See our own weakness. My system cannot improve me. If I am not taking a proper health care, do you think that my health is going to remain good? Whether a pandemic, whether whatever it is, ultimately we have to take care of my health. The same thing is that the company is unhealthy and banker has to be conscious about his health, because earlier, I do not know right now, Mr. Sinha, correct me, earlier we are giving the health code of the company. Now we have SM1, SM2, 0, whatever it is. That was the system. System was eroded slowly. BFR was failed because of, not because Mr. Goel, BFR was wrong system. We failed. CDR was nothing but a pre-packed restructuring. We failed, not mechanism failed. It was a informal legal framework. And come to surface C, we failed because we never thought about the after taking the action, what mechanism is required. I'm advising the banker. We should know the mechanism also. Legal fight you cannot take away from anyone else, but how we are good in our own documentation, how we are good with our own system, how we are understand our own secured assets. Ultimately, we are a secure creditor. Now, come to IBC. When the IBC start, whether the RP is only demanding, debtor give me this thing, debtor. Why the RP is not demanding with the COC, whatever the document you have in your possession, because you are supposed to make the inspection every 6 months and every year. I myself made the inspection in the companies I was a law officer, also I was looking finance, also institutions. We are going with the finance team also, looking with the legal issues, looking with the finance issues, technical issues. There is a proper documentation. Today, in a technology mood, we don't have a file system, and new person not able to understand the cases for himself. Okay, where is the file? What are the cases? वो तो आया computer में क्या चला गया? And no one is able to train the people in their own organization. Now come to start your function from IPC. IPC is very nice, fine, no doubt about it, and philosophically very good. Ultimately, no banker before IBC wants to not to maximize the value of the assets. No banker before I myself involved in BFR. Everyone want to find out how best is possible and how the restructuring has to be done, how the haircut should be taken. Today, nobody's talk about how much haircut taken. Today, the maximum haircut is more than 60%. This is the resolutions plan. What you talk about the valuations, and come to your mechanism for CRPC process. In CRPC, COC meeting is not only there. How the COC is handling the RP, managing the day-to-day affair, and what the information is lacking and what information we have to give. This system is almost not there, and everything depends on RP. IRP, RP is behaving like that. I am very blunt. I am sorry for many IRP, RP that now they are become a board of director. Everything is my hand. Everyone is my servant. But the reality is that this is a teamwork. You need everyone to be taken. If there is no leadership quality in IRP and RP, the whole process is going to be down. I'm facing one of the cases in NCLT also, a bad behavior of IRP. Blaming the system is very easy. Praising the law is very easy. But to achieve the goal, what is the goal? What is the end goal of IBC? End goal is, you talk about maximize value. End goal is, what is a maximize value? A lender is in a position to recover. Ultimately, lender's money is not a lender money, Baba. It's not a government money. Government ka dictation aaya aur sab bhag liye IPC mein. It is a depositor money. You look your depositor, and bank's views is more important whether we go to IBC or not, whether we go make arrangement or not. In earlier now, timeline cannot be a one timeline for every sector. According to me, my experience, in one restructuring and one resolution can take 15 days. 15 days you can conclude the resolution and go for but in some case you cannot take it 2 years, 3 years. Forget about the legal fight because of analysis, because of due diligence situation. I'm doing a due diligence one of the case, and of course it's not IBS. You believe me, I put almost 4 months because I have to invite my foreign investor. These are the issues. How can people will come and take it? And third situation, Mr. Sinha will agree with me. Where is your buyer within India? Our economy is a basically family-driven economy. Is not a professional promoter we have. You suspend the IBC and you have not allowed the promoter to take the company back. Believe me or not, whether they have committed a fraud or not, whether it is the only people will run the company and give you money back, and more than what you are taking the haircut with the third party, because you don't have a professional people. Where is the profession? This is not America where implementation of the project done by A people and operation is run by B people. यहाँ तो grandson के लिए बनाता है आदमी कि I will build up my company for my grandson, my granddaughter. You are living in a culture where all these things affecting your process. So your resolutions process is fine. That is the reason you are facing, because of bad leadership of RP and IRP. People are facing the problem. Litigation is generated unnecessarily, and these are things. And COC is not proactive in the sense that find out the defect in the process. Stage 1, stage 2. Every action has to be looked by the COC. Ultimately, is a COC company was under the control of banker earlier also, because of their contractual relationship. Read your agreement. Read banker agreement. There is a positive covenant, there is a negative covenant, there is a consequences, there is a vendor of default. If you read the positive negative covenant, you will find that everything is in the hand of the, in fact, lenders. If they implement the things at this stage, things may be much better than what we are facing. Now come to famous issue is a silver lining of liquidation. I need, Mr. Goel, your opinion. In the liquidation process in IBC, and earlier there was a process for old act, Companies Act. I handled myself one compromise in the liquidation. One of the case, even liquidation process, there is a merger, there is a compromises, there is a lot of things could be possible. But here we have given a right to the secure creditor. If you don't want to relinquish your assets, you can sell it. So that means there is two processes going on. One is a secure lender will sell the asset, unsecured asset will be sold by the liquidator, or you can wait, let once asset will be sent, then we will send. Managing this process under this regulation law is itself create a problem. Many times I think that they are relinquishing the assets also, but what in fact provision we are making it without knowing the ground. Liquidator has to be sell the assets in totality, because you will get more valuation if there is a one asset in the hand of the liquidator. There may not be a consensus between the secure creditor. They thought that I can sell the asset, they can sell the asset before that. Usme kya problem tha? Now come to this issue. I have marked.
You have raised a nice this thing, because we have to move on to the silver lining.
Just a minute, I am concluding.
We have to move on to the silver lining.
Anil ji,
Anil ji, can I just respond?
I'm concluding. I'm concluding because I have made a notes a lot of based on my experience also. Because in one of the case I was official liquidator appointed to the Bombay High Court, and I handled and closed the issue within 1 month. You will surprised to know, because company was not big, and IDBI was also involved, ICCI was involved. I was from IFCI. There was a special provision. They made me a official liquidator because I have made the nothing else. Stakeholder ko sabko bula liya. I talked with each and other how to go for that, how do you recover the money. Ultimately, sir, everyone is interested to recover the money, Baba. With all due respect, no banker is interested to develop the Indian economy. अरे मेरी इकोनॉमी ठीक नहीं है, मैं पूरे वर्ल्ड की इकोनॉमी ठीक करने जा रहा हूँ. This is all foolish thinking. बैंकर को देखना है कि मेरे को कितना मिल रहा है.
Let us move on to the silver lining. We need to move on to the silver lining.
Now, next question, Mr. Goel, is that can we sell the asset which I have already raised, and other is third and fourth, fifth resolutions.
I think Mr.
And
Sinha
lot
also
of
would like to say
so we have to treat
about
it.
Yeah.
But I would like to, in the end, I will conclude.
I think Mr. Sinha also would like to say something about this.
Yes, Mr. Sinha.
In fact, Mr. Ali rightly talked about a few things, and definitely, somewhere people lack their organizational indiscipline also, which has led to all such things. Now, during the last, if we talk about the last 9 to 10 years, let me say RBI has come out with various things. Anyway, CDR was existing earlier, then SDR, JLF, S4A, 525, and so many things have come. Now you tell me, within the span of 6 to 7 years, so many schemes have come, and finally, we could not achieve certain things, or let me say, why we could not do. Did we ever ponder over here? Now, point is that first thing that one after the another, some schemes have come, and see, even if you cook food, you need to, at least put for some time on the gas so that it just gets cooked. So we have started the process, and at the same time, most of these schemes have been used for taking the regulatory forbearance and all for short-term goals, how to save out of NPA or something like that. And that is what, things have accumulated, and, today we are in this precarious situation where we are handling this 9.5 lakh crore of NPA. That is one thing. Second thing, sir, one thing I would say, since we are talking about the IBC, now, let me say, why not to start a good beginning in the sense, the admission of the case in IBC. Why we are leaving it to the fate that admission of the case, when court talks about 14 days, why it cannot happen in 14 days if the bankers are, because when a account becomes NPA, bankers have given enough evidence, a lot of communication, a lot of acknowledgement by the corporate debtor, by the promoters and all these things, that the default is persisting. Why can't the admission can take place within 14 days? Why, because, you are calling the corporate debtor, promoters and so many other things, and then, 1 year, 2 year, 3 years means why it has to happen like this? It's a 14 days, default is there, the corporate debtor itself has accepted the default. Then why it cannot? So once you start this beginning and give the control to the RP and to the creditors, I'm telling you, things will fall in place. It is there. This is one thing. I would also, in fact, in some forum, I have told Dr. Sahu also, and I don't know, we leave it to the, because some lawyers are also sitting over here. See, let me say, we all are professionals. We are all working, for benefit of this economy, and try to revive the things. See, when a lot of times, certain hearings are not taking place, or, we are taking a lot of time, and, because the regions are given, so many pending cases are there. See, let me say, Mr. Goel, I have seen you, I have heard you many times in the past, and also other eminent speakers. See, when we all are loaded, we have a lot of work to do. We even don't bother to work on Sunday, Saturday, holiday. There is no summer vacation, there is no winter vacation. Not that 5 o'clock I will just leave and all these things. True. What I'm doing, there is a food of thought, food for thought in the sense, why can't, we have some, where is the question that, NCLT and CLAT and all these things, they will have a summer vacation and winter vacation, and leaving all these cases. See, when you are loaded, you have so many things to resolve, you work day and night and you do it. Are you not doing it? You are doing it. This is another thing. Mr. Ali also talked about public money. See, I feel that, like I am a banker, means when I deal with the public money, I have certain responsibility. Now, when I do something wrong, it becomes NPA. A lot of investigations comes. We are going through, various investigations, CBI, these, so many staff counted things are there. Now, is it not that, those who are dealing with IBC, they are also accountable because they deal with public money? If there is any lapse or anything, which is hindering the, recovery of public money, are they not to be made accountable? I think they should also be made accountable. So there is nothing that, we can just relax. Why we are leaving it to fate? अरे वो तो ठीक है, 1 साल भी लगेगा, एडमिशन होने में, या फिर बाद में implementation होगा, उधर भी कुछ time. Why we are leaving it to the fate? I have talked to on some forum with Dr. Sahu also. So we are not able to lay that hand. We say ultimately they are also part of the same economy, same country. We are also just a human being. Why can't we have take some effort or have some legislation or some legal reform or something like that? So that things materialize. I am telling you, we make all this timeline perfect. I am telling you, our economy will revive and we all will flourish. This is what is my opinion.
I think this is a wonderful.
Sir, एक चीज मैं और ऐड करूंगा, एक चीज और करूंगा. I'm sorry. One thing I wanted to add. Just one second. Can you believe me? Whether it is a DRT, whether the NCLT, they don't have a proper infrastructure and the people to deliver the goods. Forget about it. That is a major problem.
I'm only on that. I'm saying what you and what Mr. Sinha is saying is absolutely right, that the overall size of the infrastructure has to be increased. But I somehow have interacted with a lot of members, and I have seen the life of a member of NCLT, and they actually live a very, very occupied life, and this particular life, because they have to hear 50, 60, 70 cases when the courts are open, and then they actually, in each and every case, there is an order, maybe 2-line order or 2-paragraph order, and someone has to type it and someone has to sign it. And before signing, each and every order has to be read. So that particular scenario, when you are supposed to hear the 50 cases, let's take an average of 50 cases that you hear in a day, and then somebody types and you read and then sign it, and then on an average, one order or one order on an average per day, which runs into between 20 to 40 pages. Whenever you dictate an order or even to read an order which is between 20 to 40 pages, you need to read the application, you need to read the reply, you need to read the rejoinders, and all the dates and the names have to be matched with the everything. So we have not been able to find so many errors in the NCLT order. So life of a member, I know it very well because I personally interact offline with some of them, and they are doing the best possible things. Overall size of the infrastructure has to be enlarged to a great extent, not a smaller extent, to a great extent. So that is very, very important message. That's a very, very important message. But the people who are working, they are working to their best. I understand that they are working to their best, and there is nothing that we can say that they are not working. So coming back to, I think Mr. Ankur also, you would like to say something about this silver lining, Ankur.
Yeah.
So the silver lining is something that's still missing in our discussions. Why the liquidation, and how the liquidation can somehow improve the valuation also. How the liquidation can actually bring back something which was already lost to the debtor. How that has actually finally is bringing back to the creditors. This is what is the silver lining. So can you just give your opinion before we start the questions picking up?
Yeah, sure, Anilji. So I have just heard Sinha Sahab, Anjuji and other panelists, and a different view on a different aspects. We heard about the various things on the reforms which need to be there. But as a lawyer, as an ex-banker, as also a resolution professional, I think we have missed about the role of the COC in the whole context of the resolution of the company. Because though there have been a lot of cases where the bankers has to take a quick decisions, because we have to see when a RP is working, he is working more as an entrepreneur, he has to take some quick decisions. He has only a limited time, 180 days or where he has to suffer the non-support from the promoters, from the company staff. At the same time, COCs also see something like Ishtaq Ali Saab said that the only objective is the recovery. Whereas when the objective is given, you have to revive the company. So all this situation when goes and with the judiciary timelines and everything, so it become a time-consuming process. In the way we have the asset stripping and a lot of things happen, and when the finally situation arrives, we come into the situation where the CRP period is over and the liquidation bell is ringing, because as an RP or as other person, all the IBBI and other will asking for your timelines. So it is a very pressure games, and when the liquidation comes, so how at that point of time where all the resources is stopped, lot of investors and lot of peoples, and we have seen they don't want to participate in the CRP process in the hoping that let the company go into the liquidation, they will get a better value there rather than coming into the CRP process. So this is also a thought process which has been emerged. If during the CRP process, let it the things can continue, the valuations and everything will further go down, and they can get an asset at the time of the liquidation at a much cheaper value. So different things, different way things are happening, and we have to see as a when we acting as an RP or as a lawyer, or when we see in the IBC, it is just not a recovery mechanism. It see that all the stakeholders, not only the bankers' money, it is the employees which are involved. Yeah, there are other creditors, vendors, everybody is involved. So like Ishaq Ali Saab said, as an ex-banker, he said the recovery is the only thing. No, recovery is only one of the measure. You have to see that the company should get revived. And at the same time, because the liquidation, like Goel Saab said, is the silver lining. When all the process, these things within the timelines have been gone, what is left? Left is the liquidation. And at the time of the liquidation, even then, if we can, as a banker, as a recovery, as other creditors, we get some value, then we should get it. Otherwise, like Ishaq Ali Saab said again, that the banker is always the control. If they have the control, the things should have not gone that far, because certain things, somewhere things have gone not right. And again, it's not all the promoters are thief. It's not all the promoters are thief, because we are dealing with lot of clients. There are some genuine cases where due to the market conditions, the accounts have become NPA. Even from the banker side, when we are dealing with the NPA accounts, or as a RP, we have to see whether some account is a fraudulent account or whether it's a normal business condition which has made the account NPA. So if we see that account from that thinking, our perspective will change. We see whether it can be revived, what action can be taken, and then even at the liquidation, asset has to be preserved, what value can be obtained. All those things can come as a strategy. So we have to see the IBC in a holistic view.
No, that's very very important, Ankur, that the IBC as a holistic view. So I think Mr. Rajesh, Dr. Rajesh Singh, in case somebody is there to see if there are some important questions, now we would like to take some questions. And before we conclude this session, because already we are only 1 minute left from the scheduled time, and we cannot blame the earlier session one because they handed over to us 2 minutes before their time. So we can't even blame them. But then we have an advantage of being the second session and the last session that we can extend by 10 minutes in case the questions are there. And also we have to just get some concluding remarks from some of the eminent speakers. Dr. Rajesh, is there any question that you can read out? Or I have just forwarded me 2 questions. So these questions are somehow not important to the liquidation subject today. So these are like generalized questions. But if you have any,
Anil sir, whatever question.
Yes,
Anil
yes.
sir, whatever question we receive, I have forwarded to you on your WhatsApp.
Okay.
So kindly.
Okay. Those both. That means that the questions are not.
And another thing, sir, if you wanted to, another things you wanted to extend the 10 minutes, please kindly go ahead. Okay.
So we got the 10-minute extension. That's wonderful. Thank you, Rajesh. So the one question which has come is the IBC on account of labor law related compliance is feasible at this point. This is a very short question. What I could understand is that can the labor laws be complied during the CIRP? I'm just taking this question as such. So the Anju can answer this question, because the labor laws, can the labor laws be complied with during CIRP? I think that's the meaning that I can have this question. I think, Anju, yes, we can. We need to comply, as everyone knows that the during CIRP, the corporate debtor has to be completely compliant. Whatever law it may be labor law, it may be GST, it may be TDS, it may be any kind of law. It has to be complied, completely a compliant operations during CIRP. So the labor law also has to be complied, including the retrenchment compensation, including the gratuity, including all the laws has to be complied with during CIRP.
Not only CIRP, I think in liquidation also we have enough judgments now that the gratuity, PF and other things of the laborers has to be paid in priority, and even in this liquidation we have to comply with that. Yes. And
no, I feel like there is a different judgment which has been given by a 3-bench NCLAT, where it says that the gratuity, superannuation, and the leave encashment is not having the super priority. The earlier judgment has been kind of overruled, which was earlier given by Mukhopadhyay Sahab. So now this bench has given an order which says that unless there is a fund available in the company, the gratuity, superannuation, and I think the third is the leave encashment. This is not the priority. So this is part of the this is not outside the liquidation estate. So that has actually been amended. So during liquidation, one, that each and every employee will be considered as discharged, fully discharged, unless the liquidator keeps some of them, retains some of them. So in case liquidator retains any of them, then of course all the laws are applicable on those employees who are being retained by the liquidator. Secondly, similarly during CIRP also, whosoever employees are providing services to RP, they have to be completely compliant and they have to be paid. That's very, very important. So the labor laws has to be complied with, but then during liquidation, it depends how many employees that you retain. In the other question, in the present times of COVID, there is pertinent requirement for a robust electronic technical infrastructure for NCLT, NCLAT to deal with the increasing IBC litigation. What are the steps taken to address the same? We already have discussed this issue, that it requires a complete overhauling of the complete infrastructure, requires a very big enhancement. Not only in physical manner, also the vacancies are there. The process of recruiting 20 members is still pending. If those members are recruited, some new benches are made, so that actually will solve the problem. And the other thing which probably the government is thinking, that by way of suspension of 1 year, the impact would be much lesser in the short run. But with the increase of 1 lakh rupees to 1 crore, the Section 4 amendment, the new applications from the operational creditors are reduced to a great length. So in case we understand, after this amendment in Section 4, the new applications which have been filed by operational creditors are reduced to actually to 20 or 30%. So that load will come down. So what we were trying to see, yes, please, Sanju.
Yeah,
yes.
I would like to add somewhere here. I'm just thinking out of the box, actually. So as far as the technical members are concerned, or judicial members are concerned of the NCLT or NCLAT benches, so I think what I have been hearing from the very beginning, because of the lack of experienced judges, we could not. So obviously physical infrastructure is one part of that. Definitely we need to improve on that. But I think in the want of talent also, means the right skill for being the judges. So why can't we have some judicial exams to having judges and something like that? So can we have some exams or some methodology to having actually good judicial members or technical members for NCLT and NCLATs from the experienced people, like maybe, because in any case the age limit is higher for these judges, and the retirement age is also higher. So maybe some experienced, ex-directors, CEOs of the companies, or ex-lawyers, senior lawyers, so whomsoever. So if we can design, say, the way we have designed a thing for RPs, making the RPs, there could be a procedure for making the judges as well. That's my just, kind of a creative thinking sort of a thing, one thing.
True.
And yeah, so means we are on a crux, because we see, in any case, we are a country which is the population is the, I think, biggest problem, and everywhere is the number is the problem, because we have larger number everywhere. And as Sinha sir and the Ishtiyaq Ali ji is said very correctly, in the operational creditors application is only one place where the judicial members or the NCLT might take longer, because there can be disputes and they have to look into every aspect of the application. But in the Section 7 application, why it happens that sometimes it takes even years and more? to accept the application or accept the initiation of the CIRP, I even really do not see any reason why, I know obviously they are worked up a lot, but in section 7 applications, clearly I see that the benches should not take that much of time, because
I think
default
it is very
is
right.
there, entry is there, and they can be at
You are
least
right.
accepted. Yeah, they can be at
Anju, you
least
are right.
accepted. 7 or 10, 9 or 10 can be taken
100%.
time. That I understand. But 7 are very
Fine,
clear
fine,
cut.
fine, fine, fine.
Yeah. So
No, I think you're right.
Admitted liability, admitted
What we
liability.
can no, Anju, what we can conclude, is that yes, of course, some of the RPs need training, some of the valuers need training, some of the COC members also need training, and some of the members of the NCLT also need training. So that's what we should conclude.
Yes, true.
All the stakeholders somewhere at
we are all learning in the process.
we're all learning in the process,
Exactly.
and
True,
everyone
true.
needs some training at some point of time. Nobody can say that all the RPs or all the lawyers all are perfect. Nobody can say that, or even the COC members are not perfect. However, as far as the process of selection is concerned, it was required to be faster because the examination and all that, it becomes a little tedious and a long time-taking process. So this is one scenario that, of course, so far it has been successful. The orders which are coming from the benches are not that incorrect. It is good orders that we are looking at, the good orders. So
Well, sir, I would like to just add one
yes, Sunil. Yes.
A very good suggestion has been made by Anju ma'am. But the thing is, what I would suggest that by the time that change happens, the benches can take the advice and consultancy from the technical experts of the field, so that their orders are improved.
I think they are getting now the legal associates. They are getting an assistance of legal associates now in the benches, and the most of the orders are getting drafted by the legal associates at times, because it depends whether the vacancies are there. How many are filled or not, I'm not sure, but the vacancies are there. So, Sinha Saab, like, we need to discuss one thing, like why this liquidation is a silver lining. I will take an example, because you as a banker must have suffered in the past on behalf of the bank, that suppose there is a thermal power plant which is not operational, suppose there is a hydro power plant which is where the water has completely dried up. So all these plants, all these larger projects where or a retail store, chain of a retail store, where there is no property and everything is constructed on a leased properties. So the option available before the IBC was negligible. There was no option available. Under SARFAESI, we could never take an action on a running company where 2,000 workers are already working, maybe at 30% capacity utilization, so we could not take possession. Similarly, for all those assets where even if we take the possession, we would not be able to sell it, because that as a business can be sold, but assets cannot be sold. So then this silver lining of so now all those companies are coming into IBC and finally going into liquidation. So I think, is it a better, or is it something that it is not required? So this is what is a silver lining, because I understand that the assets are now coming to the creditors rather than staying with the debtors.
Sir, I think IBC has been tried on all the sectors. Okay, so whether it's means EPC, manufacturing, or even real estate. And let me tell you, means there are certain discipline. If we fine tune this IBC, I'm telling hats up to the Dr. Sao's team. The way they have over the years they have amended the things and tried to streamline the process. I think I'm not saying that it's a one size fit. Things are there, but I would say that it will definitely address, means all the aspects of a resolution process, means what we are looking for. So that definitely, means let us not talk about the specific sectors. Yes, let me say EPC has not shown a good result, means hardly 10 to 12% recovery. Manufacturing to some extent has shown better recovery. So sector-wise different thing, but what I'm trying to say, if we streamline the process, where Dr. Sahu or IBBI team has already taken a lot of efforts, if we discipline that process, I'm telling you, we will be having a very great time.
So I think we already have consumed our extended time of 10 minutes. And while I thank all the eminent speakers and all the participants, however, I have to give this formal thanksgiving and concluding remarks to Sahib Narula, So Sahil, I think it is now your turn for saying thanks and also concluding the session.
Yes, thank you so much, Anilji. So I would now wear the hat of a council member of IBC, ASSOCHAM's IBC Council of IBC. So thank you so much, first of all, to Dr. M.S. Sahu, to himself be present here and share his thoughts and give light on the current issues, especially revolving around the pandemic and the suspension of IBC for a year, and what are their views as a regulator and how they see the infrastructure and the regime being evolving. So thank you so much to Sahu Saab. Along with him, we would like to extend our great thanks to Shri S.C. Garg, who also shared his valuable time and inputs to us. Along with that, I would also like to thank both the moderators, the moderator in the first session, Dr. Charan Singh, and our Mr. Anil Goyal, the moderator of our session, along with which I would also like to thank all the attending panelists as well as all the attendees. So what we would like to do, as also discussed earlier, was that at ASSOCHAM, we have heard all the various panelists and also taken cognizance of their inputs, and this shall be taken into effect, and we shall be compiling it all together, making notes and sharing it with the regulators and the various stakeholders. So that is what we shall be doing at our end post this, as a takeaway to give back to the regulators. And we have seen in the past that the suggestions and inputs given by ASSOCHAM have been taken very seriously at all levels by various regulators, and we wish and hope for the same to happen as an outcome of this summit as well. And last but not the least, I would also like to thank the very hard-working team at ASSOCHAM, Kushagra, Piyush, and Rajesh ji, without which this would have not been possible, and we would have not been able to come together at this platform and have a wonderful summit. With this, I would like to thank everybody to be a part of this wonderful summit, and wish all the very best to everybody, and to stay safe and have a healthy time ahead. Thank you.
Thanks, Mr. Narula.
Thank you, Al.
Thank you.
And
Thank
to
you.
all
Thank
the
you. Thank you.
organizers.
Thank you.
Thank you all the speakers.
Thank you.
Thank you. Thank you very much. Thank you.
Thank you.